The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
We will hear argument first this morning in case number 19-431, Little Sisters of the Poor versus Pennsylvania, and the consolidated case. General Francisco.
Mr. Chief Justice, and may it please the Court. In 2011, the government required employers to provide insurance coverage for all FDA-approved contraception, including many religious employers who objected to the coverage, sparking years of litigation. In 2017, in the best traditions of this country's commitment to religious liberty, the government sought to resolve the issue by promulgating new rules exempting those employers who objected to the mandate. Those exemptions are lawful for two reasons. First, they're authorized by Section 13A4 of the ACA, which requires employers to provide the types of coverage that the Health, Resources, and Services Administration provides for and supports. So it authorizes the agencies to require most employers to provide contraceptive coverage while exempting the small number of employers who have sincere conscientious objections. But it doesn't create an all-or-nothing choice, require coverage for everyone or no one. Otherwise, the long-standing church exemption, the effective exemption for self-insured church plans, and indeed respondents' understanding of the accommodation itself would also violate the statute, since the employer's group health plans don't provide the mandated coverage. Second, RFRA at the very least authorizes the religious exemption. It prohibits the government from imposing a substantial burden on religious beliefs subject to a discretionary exception. It may substantially burden religious beliefs if it can satisfy strict scrutiny, but RFRA doesn't require the government to do that. Otherwise, the government would have to divine the stingiest accommodation that a court would uphold, virtually guaranteeing a loss in every case. Neither RFRA nor the ACA requires that result. I'd like to begin with the Section 13A4 issue, which requires employers to provide whatever coverage HRSA provides for and supports.
General, before you get to that, I'd like to ask you a question. I wonder why it doesn't sweep too broadly. It is designed to address the concerns about self-certification and what the Little Sisters call the hijacking of their plan. But the RFRA exemption reaches far beyond that. In other words, not everybody who seeks the protection from coverage has those same objections. So I wonder if your reliance on RFRA is too broad.
I don't think so, Your Honor, for a couple of different reasons. First, RFRA itself in its operative language prohibits the government from imposing a substantial burden subject to a single exception. And when you look at that exception, what it says is that the government may impose that burden if it thinks it can satisfy strict scrutiny. So once there's a substantial burden, the government has the flexibility to lift it in different ways, including through a traditional exemption. Otherwise, this court's decision in Zubik doesn't make a whole lot of sense, because there the court ordered the government to consider further modifying the accommodation, even assuming the accommodation fully satisfied RFRA. That doesn't make sense if RFRA prohibits anything that it doesn't affirmatively require. But secondly, even if you...
Thank you, counsel. Justice Thomas? Justice Thomas? Well, we'll come back to Justice Thomas. Justice Ginsburg?
The glaring feature of what the government has done in expanding this exemption is to toss to the winds entirely Congress's instruction that women need and shall have seamless no-cost comprehensive coverage. Seamless, no-cost comprehensive coverage. This leaves the women to hunt for other government programs that might cover them. And for those who are not covered by, say, Medicaid or one of the other government programs, they can get contraceptive coverage only from paying out of their own pocket, which is exactly what Congress didn't want to happen. And in this area of religious freedom, the major trend has not to give everything to one side and nothing to the other side. We have had a history of accommodation, for tolerance here, respect for the employer's workers and students who do not share the employer's or the university's objections to contraceptives. And every time we have dealt with this subject, we have assumed that there would be a way to provide coverage that would not involve any cost sharing by the individual. So in Hobby Lobby, we assumed that the self-certification was okay because women could receive coverage without any cost sharing by the organization, the group health plan, or the participant. And then in Wheaton, we said nothing in the interim rule affects the ability of applicants, employees, and students to obtain without cost the full range of FDA-approved contraceptives. And finally, in Zubik, we said we instructed the parties to endeavor to put in place an accommodation of the employer's religious exercise while at the same time ensuring women covered by employers' health plans, ensuring that women receive full and equal health coverage, including contraceptive coverage. So you have just tossed entirely to the winds what Congress thought was essential, that is that women be provided these services with no hassle, no cost to them. Instead, you are shifting the employer's religious beliefs, the cost of that, onto these employees who do not share those religious beliefs. And I did not understand RFRA to authorize harm to other people, which is evident here, that the women end up getting nothing. They are required to do just what Congress didn't want.
General Francisco, could you respond?
Yes, respectfully, Your Honor, I think I would disagree with the premise of your question, because there's nothing in the ACA, as this court recognized in Hobby Lobby, that requires contraceptive coverage. Rather, it delegated to the agencies the discretion to decide whether or not to cover it in the first place, and we think that that also includes the discretion to require that most employers provide it, but not the small number who have sincere conscientious objections, because otherwise the original church exemption likewise would be illegal, as would the effective exemption for self-insured church plans. But even putting
the church itself has enjoyed traditionally an exception from the very first case, the McClure case in the Fifth Circuit. The church itself is different from these organizations that employ a lot of people who do not share the employer's faith. And I thought that Congress had delegated to HRSA for its expertise in what contraceptive coverage women would need.
Briefly, General Francisco?
Yes, Your Honor. Respectfully, the church exemption and the effective exemption for self-insured church plans tweet much more broadly. They encompasses not just churches and their integrated auxiliaries, but elementary schools, high schools, colleges, universities, charitable organizations, hospitals, and other healthcare organizations. So I don't think that they're authorized by the so-called ministerial exception. Rather, they're authorized by Section 13A4 and by RFRA.
Thank you. Justice Thomas?
General Francisco, a quick question about HRSA's broad authority. You seem to as you did in your last answer, suggests that ACRA has almost unlimited authority to both create guidelines and exceptions from those guidelines. First, if you would give us just an idea of what standards are to guide that their discretion and the services that are provided, as well as the exemptions that are offered by the guidelines.
Yes, Your Honor. I think there are three limitations that I would point to. First, because HRSA it has the discretion not to require any contraceptive coverage at all, as this court acknowledged in Hobby Lobby. I think that plainly encompasses the discretion to require coverage by most employers, but not the small number with sincere conscientious objections. Secondly, it's further constrained by the APA's requirement for reasoned decision-making, which prohibits which would prohibit arbitrary exemptions. And third, I think that the term preventive services in the statute itself potentially provides yet another limitation, since at the very least that would encompass the types of things that governments traditionally take into account when regulating in this area, including the impact that their regulations would have on religious believers. And I'd point you to the Federal Register, 83 Federal Register at 58598, where the government goes through in detail the history of according conscientious objectors protections when regulating in these very sensitive medical areas.
At what point do you run into a non-delegation problem?
Your Honor, I don't think we have a non-delegation problem at all here for the reasons we've said. I think all of those would establish limiting principles, including the phrase preventive services, which at the very least would limit what the government can do to the types of things that traditionally it has done when regulating in this area. If I could just give you a quick hypothetical. Suppose the Congress delegated to the Department of Defense the authority to create a draft. I think that would necessarily include the authority for the Department of Defense to craft conscientious objections to the draft, precisely because that's the type of thing that governments traditionally consider in that area. Likewise here, in regulating in sensitive medical areas, governments traditionally take into account the impact that their regulations have on conscientious objectors.
Thank you, General. Justice Breyer?
Good morning, General. I had exactly the same question as Justice Thomas's first question. So about what are the standards that govern when the agency can make exceptions and how and what they must look like. So if you have anything to add on that, do. And if not, thank you very much, and you can go on to the next question.
Your Honor, the only thing I would add is that I think all of these limitations would fully make sure that any time HRSA is exercising its discretion, it's doing so in a rational way. After all, this is the very same discretion that was used not just to adopt the church exemption, but also the effective exemption for self-insured church plans, and under respondents' understanding of the accommodation, even the accommodation itself, since in each one of those three instances, the employer's benefits plan is not providing the mandated coverage, and in two of them, nobody is providing the mandated coverage. And so if you concluded that the agencies didn't have this discretion, that would undermine the validity of the church exemption, the effective exemption for self-insured church plans, and potentially the accommodation more broadly.
Thank you.
Justice Alito?
General, what factors other than medical need can HRSA or could HRSA take into account in deciding which preventive services and the degree to which preventive services would have to be covered by an insurance plan? For example, could it take cost into account?
Well, Your Honor, if it took costs into account, I think that the first question would be whether the manner in which it took costs into account satisfied the arbitrary and capricious standard. And I certainly do think that they could take costs into account in deciding what types of preventative services to require. If, for example, there was a particular type of preventative service that was a new technology that was actually quite helpful, but it was cost prohibitive for just about every employer or any insurance company to cover. I certainly think that HRSA could take that into account in deciding whether or not to require it pursuant to the guidelines issued under Section 13A4.
This broad issue has been before this court on a number of prior occasions, and until this case, I hadn't seen the argument that the Affordable Care Act did not allow HRSA to make any exceptions based on conscientious objection. When did this argument first surface?
To my knowledge, Your Honor, it first surfaced in this litigation, but if you look back to the promulgation of the original church exemption back on August 3rd, 2011, and you look at the Federal Register notice, it makes crystal clear that the church exemption was based on Section 13A4. In describing Section 13A4, the government determined that it had the authority under 13A4 to promulgate the church exemption, and that's likewise the reason why the effective exemption that covers all self-insured church plans and the accommodation more generally is likewise lawful under 13A4. Under my friend's position on the other side, I think all of those things would violate 13A4.
Thank you.
Thank you, General. Justice Sotomayor?
General, first of all, you keep calling it a small number of women who won't get coverage, but I understand the figure to be somewhere between 75,000 and 125,000 women, correct?
Well, Your Honor, yes, that's the number that would be affected by the exemption as compared to the original church exemption and effective exemptions that affected around 30,000 women. But I would note that in this particular litigation, the respondents haven't yet identified anyone who would actually lose access to contraception as a result of these rules. I think presumably because access to contraception is widely available in this country through many other means besides forcing a
Let's go there. HHS decided that contraceptives were a preventive service required under the Act. Now you say it has to take care to both promulgate the Act and accommodate religious objections. But in your calculus, what you haven't considered or told me about is the effect on women who now have to go out, as Justice Ginsburg said, and search for contraceptive coverage if they can't personally afford it. And I just wonder if there is no substantial burden, how can the government justify an exemption that deprives those women of seamless coverage?
So, Your Honor, 2 points. First of all, I think 13A4 is what provides them the discretion to do it, which is what they did in the effective exemption that covers self-insured church plans. That imposes no more or less of a burden than this exemption does. But putting that to the side, RFRA itself at Section 2000BB-4 explicitly permits any exemption that doesn't violate the Establishment Clause. And here, I don't think there's any plausible argument that the exemptions violate the Establishment Clause under this court's decision in Amos, which upheld the Title VII exemption to religious employers, which, after all, authorize religious employers to fire an employee for religious reasons. And since it's permitted under RFRA, and it's permitted under Section 13A4, I don't think any of these considerations undermine the validity of these final rules.
Thank you, counsel. Justice Kagan?
Thank you. Good morning, General. I'd like to go back to the Chief Justice's first question, which was about whether this rule sweeps too broadly. And I understand your concern about giving agencies some leeway so that they don't have to think through thousands of accommodations in their head and then find the narrowest one possible for every person. But that's not really the situation we're in with respect to this. There was an existing accommodation in place, and some some employers had objections to that accommodation, the Little Sisters and some others. And even assuming that those objections needed to be taken into account, the rule sweeps far more broadly than that and essentially scraps the existing accommodation even for employers who had no religious objection to it. And sort of by definition, doesn't that mean that the rule has gone too far?
No, Your Honor, for two reasons. First of all, the accommodation is available. It's not been scrapped. But secondly, including contraception as a seamless part of your insurance plan doesn't actually cost employers anything. So there's no reason why an employer who doesn't object to providing contraception as part of their plan, whether through the accommodation or otherwise, would invoke the exemption, since they would be depriving their employees of a benefit to which they do not object, and that doesn't cost them anything. But I would add,
do you have any evidence that the current exemption is being availed, that only employers of the Little Sister kind who have complicity objections are now taking advantage of the exemption? I would think that there would be a lot of employers who would say, we don't have those complicity beliefs, but now that you're giving us an option, sure, we'll take it.
Your Honor, I would respectfully think that that would be irrational, given that employers would then be depriving their employees of a valuable benefit that doesn't cost them anything, because it doesn't cost any money to add contraceptive coverage to an insurance plan. It's a cost-neutral coverage provision.
Well, why couldn't you just have written the rule to cover only those who have objections to the existing accommodation? In other words, those who have these complicity-based beliefs that the Little Sisters have.
Well, because, Your Honor, I think here there's no reason to think anybody would do what you're suggesting, and the original burden stems from the contraceptive mandate itself. And so I guess what I would point to is cases like Ritchie against DeStefano, which at the very least, if you don't accept my broader argument, give the government flexibility in the face of potentially competing statutory obligations. That's the case where the court said...
Justice Gorsuch?
General, if you just continue, I'd like to hear the rest of your answer.
Sure. I was focusing on Ritchie against DeStefano, which I think gives the government flexibility when it's facing potentially competing obligations. That's the case where the court said that an employer could violate Title VII's disparate treatment provision if it had a substantial grounds for believing it would otherwise be violating Title VII's disparate impact provision. It's the way that court reconciles statutes that put parties in the place of having to decide whether to violate one at the expense of the other. And here, I think we at the very least have a strong basis for believing that the prior regime violated the Religious Freedom Restoration Act, and that gives us the discretion to adopt a traditional exemption, which, after all, is the way that the governments have traditionally accommodated religious beliefs. And I think that's particularly clear here, since one, RFRA both applies to and supersedes the ACA, and two, even if you don't think that the ACA authorizes exemptions, even though we think that it does, there's nothing in the ACA that prohibits exemptions.
Thank you, General.
Justice Kavanaugh?
Thank you, Chief Justice. Good morning, General Francisco.
Morning,
your colleague on the other side says the text and structure of the ACA make plain that Congress delegated HRSA authority to oversee guidelines defining what preventive services for women must be covered, not who must cover them. Can you respond to that argument?
Yes, Your Honor. Respectfully, that is not what the ACA says. Section 13A4 says that employers have to provide whatever coverage HRSA itself provides for and supports. Here, HRSA does not provide for and support coverage by the small number of employers with conscientious objections, but it does provide for and support coverage by everybody else. So I think our position follows plainly from the plain text of 13A4 itself, whereas respectfully, I think my friend's position on the other side is irreconcilable with that statutory text. They're trying to put sentences into that text that simply do not exist.
Thank you, General.
Mr. Clement?
Mr. Chief Justice, and may it please the Court, from the very beginning, the government recognized that its contraceptive mandate implicated deeply held religious beliefs, and so it exempted churches and some religious orders. And Congress recognized that the mandate was not some sort of categorical imperative that demanded universal compliance, and so it exempted tens of millions of employees under grandfathered plans. Thus, from the very beginning, the government's refusal to exempt the Little Sisters from the mandate and its massive penalties has posed a glaring RFRA problem. The federal government finally got the message and exempted the Little Sisters. That exemption remedied the RFRA violation and followed the best of our traditions. Nonetheless, the Third Circuit invalidated it by concluding that the regulatory accommodation satisfied RFRA and the government was powerless to go further. That decision is doubly flawed as the regulatory mechanism plainly violates RFRA, and RFRA does not impose a rule of parsimony or limit the government to the least accommodating alternative. The Third Circuit's reasoning was plainly mistaken as to the substantial burden analysis, as its reasoning really cannot be squared with this Court's decision in Hobby Lobby. After all, the penalties that enforce the mandate here are the exact same penalties that underlie the basic contraceptive mandate in the Hobby Lobby decision itself. And so when the government imposes a burden on religion by telling the Little Sisters that they have to comply with the mandate or the accommodation or else, when the or else is massive penalties, that plainly provides a substantial burden on religious exercise. At the same time, the compelling interest analysis also works in favor of the Little Sisters for two basic reasons. First, the government has shown its ability to exempt churches and other religious orders from the very beginning. And then secondly, in the grandfathered plans exemption, the government has shown its ability to exempt tens of millions of employees who do not even have religious objections, but only object or are only exempted for reasons of administrative convenience.
Mr. Clement, your client, the Little Sisters, do not object to their employees having coverage for contraceptive services, right?
The Little Sisters don't have any objection if their employees receive those services from some other means. Their objection essentially is to having their plans hijacked and being forced to provide those services through their own plan and plan infrastructure.
So if you had a situation where the certification was not necessary, in other words, the government finds out that the employees do not have contraceptive coverage through some other means, and you do not have the hijacking problem that you refer to because the insurance cover would not provide the services through the Little Sisters plan, but could provide them directly to the employees, then why isn't that sort of accommodation sufficient? I didn't understand the problem at the time of Zubik, and I'm not sure I understand it now.
Well, I don't think we would have an objection to simply objecting to the government, and then if the government has some way to provide the contraception services independently of us and our plans, we've never had an objection to that. But the government has insisted throughout this whole process that we not just be able to have an opt-out form and an objection form, but that same form serve as a permission slip to allow the government to track down TPAs and others to provide services through our plans. And that's always been the gravamen of our objection. It's never been an objection to objecting itself.
Well, the problem is that neither side in this debate wants the accommodation to work. The one side doesn't want it to work because they want to say the mandate is required, and the other side doesn't want it to work because they want to impose the mandate. Is it really the case that there is no way to resolve those differences?
Mr. Chief Justice, in the wake of the Zubik remand order, there was a lot of back and forth between the religious objectors and the government. And I don't think that there really was a mechanism to find sort of some third way, because the government has always insisted on seamless coverage, with seamless essentially being a synonym through the Little Sisters plans. And
thank you, counsel. Justice Thomas?
Thank you, Chief Justice. Mr. Clement, I'd like you to have an opportunity to comment on the questionable standing of the states in this case, as well as the proliferation of nationwide injunctions, such as the one in this case.
Certainly, Justice Thomas, I guess I would say one thing about each of those issues. At this juncture, as long as Massachusetts against EPA remains good law, we don't really have an objection. EPA remains good law. We don't really have an objection to the state standing, but I think their standing has to depend on that precedent, because as General Francisco alluded to, throughout this litigation, they have not been able to identify even a single person who would lose coverage in such a way that it would increase the burdens for the state and Pennsylvania and New Jersey. So the only way that they can have standing in this case is if they're excused from the requirement of being able to identify specific individuals who are harmed and increase their burdens. And I think there's a reading of Massachusetts against EPA that says that's okay, but that is certainly the absolute outer limit of standing, to be sure. With respect to the nationwide injunctions, that's an issue where I think that it's particularly inappropriate to have a nationwide injunction in a case like this. And the one thing we should have learned from years of litigation over the Affordable Care Act and its contraceptive mandate in particular is that the courts do not come to uniform decisions in this area, and sometimes the majority view in the circuit courts is rejected by this court. And so under those circumstances in particular, for a single district court judge to think that he or she has a monopoly on the reasoning here and should impose a remedy that affects people across the nation seems to me to be very imprudent and not something that's consistent with equity practice, or really just sort of good practice and the way that our judicial system works, since it really depends on having the circuits potentially look at these issues independently. When they divide, this court takes review, and these nationwide injunctions short-circuit all of that and put enormous pressure on this court, and it forces this court to hear cases in emergency postures.
Thank you, counsel. Justice Ginsburg?
But I would ask Mr. Clement the same question I asked the government. At the end of the day, the government is throwing to the wind the women's entitlement to seamless, no cost to them. It is requiring those women to pay for contraceptive services. If they can, first they would have to go search for a government plan. And if it turns out, as it will for many of them, that there is no other plan that covers them, then they're not covered. And the only way they can get these contraceptive services is to pay for them out of pocket, precisely what Congress did not want to happen in the Affordable Care Act. So this idea that the balance has to be all for the Little Sisters type organizations and not at all for the women, it just seems to me to rub against what is our history of accommodation, of tolerance, of respect for divergent views.
Well, Justice Ginsburg, I would say two things in response. First, I would echo what the Solicitor General said in pointing out that Congress itself did not even specify that contraceptions would be included in the preventative health mandate. And Congress went further and said, with respect to grandfathered plans, that there were other mandates in the Affordable Care Act, like coverage for people up to age 26 and pre-existing conditions, that they were going to impose even on grandfathered plans, but they didn't impose the preventative mandate. So Congress itself recognize that tens of millions of employees could be in the same position as employees of the Little Sisters of the Poor, even though there's no religious objection there whatsoever. And I think the clear teaching of RFRA is that when you're going to give those kind of exceptions to people for secular reasons, then you need to give those kind of exceptions to religious believers.
Thank you, counsel. Justice Breyer?
I have two reactions. One, of course, is that the point of the religious clauses is to try to work out accommodations, because they can be some of the most difficult to resolve disputes, and they can substitute a kind of hostility for harmony. So from that point of view, I really repeat, if there's anything you want to add, the Chief Justice's question. I don't understand why this can't be worked out. But if it can't, from what's been said so far, it seems to me the proper legal box to work it out in is whether this particular rule is arbitrary, capricious, or an abuse of discretion. After all, the religious groups say they have a real basis in objection. And the other say, look, these are women who will be hurt, who have no religious objection. And moreover, the insurance companies will be hurt because it will raise costs. And moreover, the taxpayers who pay for it will be hurt. Now, you have interests on both sides. The question is whether this is a reasonable effort to accommodate. And that, I think, is arbitrary, capricious, abuse of discretion. But that is the one thing that isn't argued before us in these briefs or in this appeal. So what do I do?
So, Justice Breyer, I think you're absolutely right that is not the nature of the objection that's been raised by the other side. They haven't said, for example, yeah, this exemption might be okay if it were limited to the Little Sisters and others who object to the accommodation, but they went too far. That is not the nature of the challenge. They haven't brought that kind of substantive APA challenge. So I think what you would do is you would reject the challenge that is before you, because I don't think any of the grounds that have been litigated before you are valid. And you could make clear in your opinion that if somebody down the road has an objection to the scope of the exemption, say they work for a for-profit company, and with respect to that for-profit company, they're not getting their services, and they think that's because the APA, because the rule here is too broad, that would be a separate APA challenge that I don't think rejecting the challenge here would foreclose. So I think that's the path forward.
Thank you, counsel. Justice Alito?
Mr. Clement, I certainly agree with my colleagues that our best tradition in this area is to accommodate diverse religious views. So I want to ask you about the interests that are involved here. On the one hand, what would the Little Sisters feel compelled to do if they lose this case and they are told, you must provide this coverage through your plan? And on the other side, I want to ask you, since this has now been going on for some period of time, whether you have identified the number of women who work for the Little Sisters who want contraceptives, but they can't get them through their employer's plan or through the insurance plan of a family member or a government program and can't easily afford to purchase them on their own.
So, Justice Alito, on both questions, first, the Little Sisters believe that complying with this mandate is simply inconsistent with their faith. And so if this burden is imposed on them, they will have to reconfigure their operations. One of the anomalies here is that the government from the beginning has exempted religious orders, but they refuse, if they stick to their knitting and do only religious services. But if, on the other hand, they do what the Little Sisters do, which is go out and provide care for the elderly, poor, and for the sick, then they don't qualify for the exemption. And so maybe the Little Sisters will have to reconfigure their operations, but there's just nothing that they can do that will allow them to come into compliance with the plan. And so with the government's mandate. And I think that's what Congress had in mind with RFRA, because they understood that when people are faced with a government obligation that their religion absolutely forbids them to comply with, that's something that the government should try to avoid at all costs. To answer the second part of your question just quickly, the Little Sisters have never complied with the mandate throughout this entire litigation. And so what that means is two things. One, no one will lose their coverage that they have now if the Little Sisters are given this exemption. And two, throughout that process, we have not heard of even a single employee who views this as a problem, presumably because many of these employees, even if they're not Catholic, because the Little Sisters hires on a non-discriminatory basis, but they've come to work for the Little Sisters understanding the mission of the Little Sisters, and I don't think they would really want to put the Little Sisters in the position that you alluded to of maybe having to stop serving the elderly poor.
Thank you, counsel. Justice Sotomayor.
Mr. Clement, assume that the government tomorrow passes a law that says every insurance company must reimburse every policyholder they have for COVID-19 vaccine. They say nothing about whether it's in your policy or not. If someone has a religious objection, they say they can be exempted from it. But you, insurance carrier, must pay for anyone who submits, who has a policy with you, for anyone who submits for a COVID-19 vaccine. Can the employer object to pay to that policy?
So, Justice Sotomayor, I think the answer is no, and if I'd like to explain kind of how I would work through that.
Mr. Clement, exactly the same rules that apply here to contraceptives, meaning all they have to do is tell the government that they object to vaccines, and by the way, we both know there are religious objectors who object to vaccines, and that they don't want their plans to be complicit in providing vaccines.
So just to provide for, I wanted to elaborate on my answer and kind of explain, how the hypo is a little bit different from the way things work. As I understood the hypo, the government obligation was imposed directly on the insurers, so I don't think the employers could object at all. Now, I think an insurer that had a sincere religious objection to providing the coverage, say like the Christian Brothers, they might be able to object. I don't think they actually have that objection, to be clear, but they could in theory, if they objected to providing compensation for that coverage, they could object, and I think it probably would be a substantial burden. In the context of COVID-19, I think that you might strike, the government might be able to carry its burden under strict scrutiny, but I think that would be the way to think through that hypothetical.
Thank you, counsel. Justice Kagan.
Good morning, Mr. Clement. I'd like to start by asking you about a response that you gave to the you said there that you had no objection to objecting, the Little Sisters didn't, and I've taken that to be your consistent position throughout the litigation. But what if an employer did have an objection to objecting? In other words, had an even more, say, extended view of complicity, so that he thought that the employer thought that extending itself made him complicit. Because it led to a sort of chain reaction whereby the employees were eventually going to get coverage. What would you say about that?
Additional factors like whether the government enforced its requirement of an objection with the same massive penalties we have here? If they did, then I think the way to think about that particular sort of objection would be that if that objection is sort of, if an objection is forbidden by the person's religious beliefs, sincerely held, and the government enforces with a massive penalty, then there is a substantial burden, and then the analysis would shift to the compelling interest, least restrictive alternatives test. In most cases, I think the government would be able to submit or sustain its requirement of at least having an objection. The irony is this might be the one context contexts where they can't because they've never required the churches, the religious auxiliaries, the other orders that stick to their knitting and engage in only religious activities. They've never had to even object. They're just
right. So that would
exempted.
suggest that even in that case, where objecting to objecting is the only thing, that you would think that the employer would prevail.
I think the employer would have
make all its same arguments, right? You know, the women can get contraceptive coverage elsewhere, and there are other exemptions to this scheme, so the employer would prevail even if it were only objecting to objecting.
I think that's right, Justice Kagan, but just to be clear, I think that has to do with the way that the government has operated this whole program. Since they've never required the churches or the other religious orders or the grandfathered plans to object, I think that puts the government in a difficult position in this hypothetical situation. But as you noted at the outset, my clients have never made that objection.
Justice Gorsuch?
Mr. Clement, a major feature of the opinion below and the arguments in the briefs, at least, was that the government had failed to comply with the procedural requirements of the APA. And I didn't want that major component of the case to go unaddressed today. I want to give you a chance to respond to that.
Thank you, Justice Gorsuch. I think on the APA, there are a number of different ways to come out differently from the way that the Third Circuit analyzed this issue. We obviously think the Third Circuit erred. In some ways, the most straightforward way is to just find that the good cause standard or exception for the original IFR here was satisfied. And we think that the good cause standard here was satisfied for the same reasons that the government had good cause, for example, to make immediately effective moderations in light of this court's order in the Wheaton College case. And we think that, likewise, my friends on the other side say there was good cause for the original exemptions and the like and the mandate because they needed to make changes quickly for for the upcoming plan years. And we think all of those same things apply here. And then, of course, another way to rule against the Third Circuit on that issue is to recognize that there's specific statutory authority here to promulgate IFRs for benefit plans, which probably recognizes the fact that these benefit plans will often have to be changed in ways that will affect sort of future plan years, and so changes need to be made very quickly. But the third way, of course, to reject the reasoning of the Third Circuit is to say, even if there was some sort of original sin in the promulgation of the IFRs, it was cured by the notice and comment that actually took place subsequently. And one feature of the Third Circuit opinion that I just want to draw attention to is the Third Circuit never faulted the government for responding to the thousands and thousands and thousands of comments it got in any kind of insufficient way. So the government, I think, on this record has complied with all of the textual requirements of the APA procedurally, and yet they've still been found to be out of compliance based on an atextual test.
Thank you, counsel. Justice Kavanaugh.
Thank you, Mr. Chief Justice. Good morning, Mr. Clement. I want to follow up on Justice Kagan's question about the objection to objecting. I had thought that would be litigated, fought out under the least restrictive alternative prong of RFRA, and the government might be able to argue that there's no less restrictive alternative available in that situation. You might disagree and try to identify a less restrictive alternative, but I had thought that's where it would be litigated. Is that correct or not?
I think, Justice Kavanaugh, that's exactly where it would be litigated, and I think why again, we're talking about a hypothetical that doesn't arise from my clients, but I think where I might come out differently from you on the least restrictive alternatives analysis is to point to the fact that the church exemption and the grandfather plans exemption have always worked quite well without requiring there to be any kind of formal objection registered. And so it does seem to me that those are essentially other ways that the government has been able to comply. And then I guess the other question, of course, is if we're in the realm where the government itself has, through something like the final rule, alleviated the obligation even to have an objection, I'm not even sure this question we're talking about would arise.
Right. No, I understand that, and that's what I expected your argument to be in that context. Second question, just to follow up on Justice Breyer on the arbitrary and capricious test, the exercise of discretion must be reasonable. What are the limits that you would identify to the government's discretion, if any?
So I would identify all of the limits that General Francisco alluded to and one more. One thing I think is a little bit artificial here about the position of the other side is they want you to look at the ACA and RFRA as if they're siloed and they don't interface. But of course, they do, and there's an obligation on HRSA to take into account RFRA as well as its authority under the ACA. And so it seems to me that an exemption for religion of the kind that's in the final rule here, I think is going to be insulated from an arbitrary and capricious challenge in a way that exempting, say, just large employers or employers incorporated in Delaware, I think all of those would be irrational and arbitrary and capricious under the APA. But here, the agency has complied with RFRA consistent with its authority under the ACA, which seems to give it a particularly strong case for its actions here to not have been arbitrary and capricious.
Thank you, counsel. Mr. Fisher?
Mr. Chief Justice, and may it please the court. The moral and religious exemption rules rest on three sweeping assertions of agency authority. First, the agencies twist a narrow delegation that allows the Health Resources and Services Administration to decide which preventive services insurers must cover under the Women's Health Amendment into a grant of authority so broad it allows them to prevent virtually any employer or college to opt out of providing contraceptive coverage entirely, including for reasons as amorphous as vaguely defined moral beliefs. Second, the agencies claim that RFRA, a statute that limits government action, affirmatively authorizes them to permit employers to deny women their rights to contraceptive coverage, even in the absence of a RFRA violation in the first place. As many of the questions have reflected, the prior rules struck a balance that permitted objecting employers to opt out, but still allowed their female employees to receive contraceptive coverage. These rules, however, exempt such employers altogether, even if they had no objection to this prior accommodation. And these rules also allow, for the first time, publicly traded companies to claim the same exemption, despite the agency's admission that no such companies ever requested one. And third, the agencies claim they were justified in issuing these sweeping new rules without first putting out a proposal and seeking comment as the APA requires. They advance an interpretation of the APA that is inconsistent with its text and purpose, and that would effectively write the requirement of pre-promulgation notice and comment out of the statute. Now, in addition, the agencies also challenge the scope of the preliminary relief entered below, and in so doing, they advanced the novel claim that federal courts simply lack the authority to invalidate unlawful agency regulations in their entirety. In isolation, the agency's arguments are incorrect. But taken together, stretching a narrow delegation well beyond its limits, finding broad affirmative rulemaking authority in a statute that doesn't provide it, bypassing prior notice and comment where the APA requires it, and seeking to vastly curtail the court's authority to invalidate unlawful agency action, taken together, these arguments make apparent that what this case is about is not the resolution of a long-running dispute, but rather the assertion of vast agency authority at the expense of Congress and the courts.
Thank you, counsel. I have a question. It was hypothetical in one of the amicus briefs that I thought was pretty good, and I haven't heard an answer to yet. And that's, say you have a couple going out to dinner, and they tell the babysitter, well, the children have to do chores, you decide which ones. I think everybody would agree that includes the authority to say not only that we have to do the dishes and sweep the floors, but Tommy, you do the dishes, and Sally, you sweep the floors, and not the assumption that each child would have to do each chore. And here, your argument about the ACCA statute is that it gives HHS the authority to specify which services have to be provided, but does not give them the authority to make determinations about who has to provide which, but instead imply that every employer has to provide everyone. So what do you?
Yes, Your Honor.
What's your answer to that?
Mr. Chief Justice, our answer is that that is the only reasonable reading of the text of the Women's Health Amendment. The who must provide is answered by the beginning of 13A. It says, a group health plan and health insurance issuer offering individual health insurance coverage shall at a minimum provide coverage for and shall not impose any cost-sharing requirements for. Now, shall is mandatory, as this court recently acknowledged again in the cost-sharing case recently dealing with the ACA. Below that language, there are 4 separate categories of services to be covered. Nobody disputes that the first 3 are mandatory, that all covered insurers must cover the first 3. The only dispute comes in the 4th one, which is with respect to women, such additional preventive care as provided for in comprehensive guidelines. And in the hypothetical that Your Honor referred to, which I believe is in the Texas amicus brief, they modified the language of this requirement by taking out the such additional language. That language is key because it answers the question of what services are insurers to provide. Well, with respect to women, it is such additional preventive care and screenings as provided for in comprehensive guidelines. So as provided for clearly modifies such additional care and screenings. It doesn't go beyond that.
Thank you, counsel. Justice Thomas?
General, just a brief question that's a little different. I'm interested in your view on standing, and with your argument for standing in this case that challenge a regulation, the government's regulation that might impact your costs, the state's costs, seems to suggest that any time there is a rule change at the federal level that affects you, you would have standing. And then that, again, following this case to its remedy of a nationwide injunction would suggest that in these sorts of cases, a nationwide injunction would be appropriate. I'd like you to comment on that. It seems to be somewhat problematic and to suggest that there's a problem with both standing and nationwide injunctions if they are this easy to get.
Thank you, Your Honor. And to be clear, we have to satisfy standing requirements just as any other litigant has to show standing. And we did in this case by showing that the rules would impose costs on Pennsylvania and New Jersey. And that is, in some ways, sort of the most basic type of injury that all parties, not just states, allege in showing harm. Now, my friend on the other side referred to Massachusetts versus EPA, which certainly recognizes that states have a special place in our constitutional order. However, we still demonstrated that based on the government's own estimates of the number of women affected, these rules would impose direct costs on us. And with respect to the question about nationwide injunctions, first of all, I want to stress that we're here in a preliminary posture. We were granted a preliminary injunction. We've moved for summary judgment. The government requested that the case be stayed. The district court granted that. We could have the case wrapped up now. The analysis with respect to nationwide injunctions is different, we submit, in the context of an APA challenge, where the ultimate remedy available is that the court shall set aside a rule that is invalid. If courts sort of were able to slice and dice rules and say, well, agency, you can enforce it as to this person, but it stays in effect as to everybody else, the result really would be regulatory chaos. So where a challenge is brought under the APA to a regulation, taking account of that final remedy that's available, granting preliminary relief on a nationwide basis is appropriate. It was also appropriate here because the district court found in a very thorough, very well-reasoned discussion that acknowledged Your Honor's concerns as expressed about nationwide injunctions, discuss this idea that there are significant cross-border harms here that simply couldn't be addressed in a more narrow injunction.
Thank you. It would seem, though, that ultimately you could get, if that's the argument, nationwide injunctions with virtually any regulatory change.
I don't believe that's the case, Your Honor. I would think that there are many regulations that are not going to impose costs on the states, directly or indirectly. And certainly in a nationwide injunction context, I think it would still depend on the specifics of the rule being challenged and the nature of the harm that the challengers are alleging. And as I again indicated, the district court really took account of all these concerns, talked about the need for percolation among the circuit courts, and acknowledged, frankly, in plain terms, that fashioning preliminary relief is an imperfect science, that district courts try their best and they're reviewed for the abuse of discretion standard. I think that is what...
you off, but I do want to get in one question about when the APA was adopted, do you think there were such things as nationwide injunctions, or were they handled on a case-by-case basis?
Your Honor, I believe there is a history, certainly, of relief going to beyond the parties to a case. Whether they were classified as nationwide injunctions is difficult to say, and I think this is dealt with very well by the various amicus briefs. But I also think that in passing the APA, Congress provided a very specific remedy. And as Your Honor stated in the travel ban case, authority for nationwide injunction has to come from either the Constitution or a statute. Well, the APA here is the authority that we would allege. We argue that the basis for this injunction comes from. It says, as a final remedy, court shall set aside improper agency action, and then it permits agencies or permits courts to stay agency action, as this court did a few years ago in the Clean Power Plan case. It permits them to enter injunctions. It permits them to postpone the effective date. And many of those remedies suggest relief going to the rule in its entirety. So I think here the text...
Justice Ginsburg?
Let's see. So I just remain troubled by the complete abandonment of the Congress' interest in saving women costs. This is going to force costs on the women that Congress wanted to provide free coverage for. I've never seen any of our prior decisions suggest that those interests could be blown to the wind and the women could be left to their own resources to cover themselves, to get policies that would cover them for these contraceptive services at a premium to them.
Your Honor, that is absolutely correct, and I think it's important to remember just how broad these rules are. First of all, there are two rules that we're dealing with. One that we haven't talked about as much is the moral rule that simply says an employer with a moral objection to providing contraception can be completely exempted. The district court noted this could, in theory, allow an employer that objects to women in the workforce, for instance, to remove itself from providing contraception. And with respect to the religious exemption, there are certain key features that really show how broad this is. First of all, it eliminates the accommodation as a mandatory requirement. So even for instance, all the various plaintiffs in the Hobby Lobby cases that this court recognized were perfectly fine with the accommodation, they are now exempt. And I disagree with my friend's conclusion that they're unlikely to take advantage of the exemption because these are entities that object to contraception. They made that clear. They were simply fine with complying with the accommodation. So I think it's likely that many of them will, in fact, opt out. In addition, as I mentioned, this applies to publicly traded...
Where would the moral exemption come from? That doesn't...
It does not. They do not rely on RFRA for the moral exemption. They claim authority under 300GG-13, under the ACA's Women's Health Amendment for the moral exemption. And as we've argued, and as the court's below found, that statute simply doesn't support the conclusion that they can create whatever exceptions they want. If their reading were correct, there would be no limits to what HRSA could do other than arbitrary and capricious review. HRSA could decide to eliminate the no cost sharing requirement. It could decide that, certain services really don't need to be covered at all, even if they're even if they're widely recognized as preventive services. It could exempt whole classes of employers for reasons having nothing to do with the reasons here. So our reading we submit is a far better one. And frankly, we have to remember, we're talking about the Health Resources and Services Administration. It's really unlikely that Congress would have delegated to that organization authority to create broad religious and moral exemptions, given that they have no expertise in that area.
Justice Breyer?
Two related questions. Thank you. One is, as you know, the statute says that they have to provide additional preventive care as provided for in comprehensive guidelines supported by the Health Resources and Services Administration. Well, read that and you get at least some ambiguity. So my question is really, given your arguments and given what may well be ambiguity, at least in the statute, why didn't you make the argument it's arbitrary, capricious, abuse of discretion? You're saying it's too broad. You're saying it'll hurt women. You point out that it'll raise health care costs and a whole lot of things. And the government has things to reply to that. But why isn't that the proper legal box? That's my first. My related question is, if you were to let a district court get at that issue, that district judge might try to reach an accommodation by saying, have you read, which you have, the brief of Phyllis Borsey and Daniel McGuire? And it points out that the prior rule did not pirate the health plan of Little Sisters. And if they think it did, and you think it didn't, well, my goodness, it should be able to monkey with it in some way so that everybody reluctantly agrees that it's okay. All right. Now, those are advantages I see of going back and making a different kind of argument. Put all your arguments in different legal box. So why not?
Your Honor, I don't disagree with any of that. I do think the rules are additionally arbitrary and capricious, and we did raise that argument in our complaint. We also argued, I think correctly, that they exceed, that the statutory authority cited by the agencies did not support the rules, and since we won on that basis, there was no need to go any further and say, well, if they had the authority, did they exercise it correctly? I disagree also with Your Honor's suggestion that the language is ambiguous. I think, as we explained, the use of the word supported in context reflects similar language in paragraph 3 immediately preceding. And all that refers to is the fact that the guidelines in paragraph 3, which are the Bright Horizons guidelines, were funded by HRSA, but actually conducted or produced by the American Academy of Pediatrics. So HRSA supports those guidelines by contracting, by funding, and I think Congress borrowed that language. And the as provided for, as I indicated, refers back to such additional preventive care and screenings. So we don't think there's an argument as to ambiguity. Now, as to whether there could be a resolution, I certainly would hope that there is. As the Borsey-McGuire brief explains, the government, the prior administration, and we do not believe that these plans are being hijacked. And to be clear, we brought this suit against the federal government. We have not challenged the Little Sisters. We have not challenged their Colorado injunction. They and all of the other parties to Zubik are protected by injunctions and do not have to comply with the contraceptive mandate no matter what happens in this case. But could there be a resolution to the narrow set of cases out there? I would hope so. But the fact that there was this ongoing dispute doesn't justify jettisoning the accommodation for everyone else, bringing in publicly traded companies, certainly doesn't justify the moral rule. And those, I think, are the most egregious examples of simply how overbroad these two regulations are.
Thank you. Thank you very much.
Justice Alito?
Mr. Fisher, you say that the Affordable Care Act does not allow the government to make any exceptions to the contraceptive mandate to accommodate religious objections. Now, if that's true, the original exemption for churches, their auxiliaries, and conventions of churches, which was established by the prior administration, violated the Affordable Care Act. But you come back and say that was required to comply with a First Amendment church autonomy doctrine. And what I'd like you to explain is your understanding of the scope of that doctrine. And let's take as an example a woman who works for a church in an entirely secular capacity, let's say a woman who cleans church property, under your understanding of this religious autonomy doctrine, does that mean that that employment relationship is entirely off limits for any federal regulation, for example, or any state regulation? For example, from Title VII's prohibition of discrimination on the basis of race, Age Discrimination and Employment Act, the Americans with Disabilities Act, the Equal Pay Act, the Fair Labor Standards Act.
Your Honor, we would not agree with that conclusion that individuals in entirely secular positions are exempt from all those requirements under the church autonomy doctrine. What we have argued is that...
But you do say that it would violate the First Amendment to require the church to provide contraceptive coverage for that woman.
Your Honor, what we are arguing is that there is a basis in the First Amendment for exempting churches in some way, that certainly there is a core of church autonomy that agencies in implementing federal law must protect.
Well, in some way, as to the provision of insurance coverage for contraceptives. I took your argument to mean the First Amendment would prohibit the government from requiring a church to provide that. Am I wrong?
Certainly. As to ministers, certainly.
Pardon me? Do I?
As to ministers, certainly. That is correct, but I would add, we are not arguing necessarily that the prior administration got everything right in the details. There have been arguments on both sides that perhaps the church exemption...
I'm not talking about the details. I'm talking about exempting a secular employee of a church from receiving the contraceptive coverage. Your argument has to be that's required by the First Amendment, or you have to say, and maybe this is your position, that the original church exemption is contrary to the Affordable Care Act.
That is not our position. We think that the original church exemption was supported by the First Amendment. We don't agree it was supported by the Affordable Care Act. We think the prior administration was wrong.
So I really would appreciate your answering my question. If the First Amendment requires an exemption for the provision of contraceptive coverage, why would it not also require an exemption for all of the other regulations that I mentioned?
Certainly in the core ministerial functions, it does. We don't dispute that. I think the question is whether...
I'm not talking about a minister. I'm talking about a woman who cleans the church.
Exactly. And our position there is, I don't think it's necessarily the case that the First Amendment required that the church exemption be as broad as it was. However, given the realities of insurance and the need for ERISA plans to be consistent, the prior administration made a decision that they were going to apply to all employees of churches. We don't take issue with that, even if that went a little bit broader than what the First Amendment requires, which is protecting individuals in ministerial functions and the church's autonomy with respect to those individuals. That's a far cry from what they did in these rules, which goes well beyond the core of the protection that the First Amendment requires or that RFRA requires.
If I could ask one other question. Explain to me why the Third Circuit's analysis of the question of substantial burden is not squarely inconsistent with our reasoning in Hobby Lobby. In Hobby Lobby, we held that if a person sincerely believes that it is immoral to perform an act that has the effect of enabling another person to commit an immoral act, a federal court does not have the right to say that this person is wrong on the question of moral complicity. That's precisely the situation here. Reading the Third Circuit's discussion of the substantial burden question, I wondered whether they had read that part of the Hobby Lobby decision.
So in Hobby Lobby, the question was essentially the degree of attenuation between providing coverage and utilizing the contraceptive care, and the court rightly concluded that the fact that others were involved didn't really matter. Here, the court said essentially that where an objection depends on the operation of the law, and here it is the legal requirements that are shifting the burden to the insurer or the third-party administrator. Courts still have a duty to inquire as to what the law actually requires of the objector. And the nature of the objection was that filling out this form made them complicit in providing contraception. They did not object to the idea of filling out a form stating their objection by itself. They objected to what flowed from the form. And the Third Circuit, consistent with the 7 other circuits that reached the same conclusion prior to Zubik, concluded that in that situation, the court can look at what's actually being required of the objector. And this finds support in the Bowen v. Roy case, where, notwithstanding the fact that applying for food stamps would have triggered the government utilizing the daughter's Social Security number, which was the nature of the objection, 8 justices still said that, essentially that does not raise a cognizable First Amendment claim, because this was
that the Little Sisters didn't understand what the law required them to do, or didn't understand the significance of what the law required them to do.
Not at all. We are simply arguing that they have not sufficiently.
They didn't understand what the law required them to do?
No, we're not saying that at all. We are saying that the harm they've alleged is not a legally cognizable substantial burden. The courts do not.
Wrong in their understanding of moral complicity is wrong.
No, we're not saying that at all. We do not challenge their view of moral complicity. What we do challenge is whether what they are saying rises to the level of a substantial burden, which is ultimately a legal test. And Congress included the word substantial for a reason, because it recognized that not every law that had an effect on religion necessarily should be subject to strict scrutiny.
Thank you, counsel. Justice Sotomayor?
Counsel, going back to the Chief Justice's example a second, clearly we understand that there's inherent power to share the chores between the 2 children, correct? However,
yes, I think
if the babysitter decides, I just disagree with the mom, I'm not going to have either of them do anything, would that be contrary to the instructions that the law gave?
That certainly would be, Your Honor. I would agree with that.
Let's talk about this situation. Here, the government's exemption is not merely saying to the Little Sisters, you don't have to provide coverage, whether it's you or a church or anyone else, but we're not going to permit, we're also saying that your insurance policies, independent actors who have a legal obligation to pay for the contraceptives that employees use, that they don't have to do it either. You're objecting to that second part of the exemption, aren't you?
So that is correct as a general matter. I just want to make one specific point, which is that Your Honor mentioned the Little Sisters. Their insurance carrier stated that it will not provide contraception no matter what, or their health plan, and because it's a church plan exempt from ERISA, the government cannot enforce it. So even if they didn't have their separate injunction, their employees would not receive contraception. We're not trying to challenge that at all. We're not trying to require them to provide.
That's an interesting point. I didn't know that. So the Little Sisters claim is actually moot here.
Well, that is why we argued. That's why we argued that they lacked appellate standing, and the Third Circuit agreed.
They lack appellate standing because they don't have to provide it. Neither does their insurance carrier. Correct? That's
correct. Yes, and as a result of the injunction.
That has nothing to do with this case, as I understood it. Well, no, that has to do with the church exemption. Church plans do not have to provide. Under the law, they're not ERISA plans, so they don't have to provide coverage in this situation, correct?
So where the employer utilizes the accommodation, the government lacks a means of enforcing the requirements against church plans because they are exempt from ERISA. So if an employer utilizes the accommodation, the church plan can decide whether or not it wants to comply, and there's no penalty if the government, if it chooses not to comply.
So tell me which part of the government's exemption you are actually challenging.
So we think the government's claims of authority for the exemptions were incorrect, but we think that the most egregious parts of the rules are, first of all, the moral rule, which I think is important to stress that that's half of what's at issue in this case. The elimination of the accommodation as a mandatory requirement, including for companies that had no problem with it, the inclusion of publicly traded companies and large universities, and then two other points. One, to claim this exemption, companies do not have to provide any specific notice to their employees. They can simply, include the fact that contraception isn't covered in all of the other ERISA notices that they mail out. They don't have to say specifically, we have this objection, we are not providing coverage. And in addition, they don't have to show any sort of substantial burden. They don't have to send anything to the government saying, we believe we're burdened for these reasons, we have these objections. So there's really no way to evaluate, for instance, whether a company is sincere in the nature of its objections. That is part of the RFRA analysis. And, as the court acknowledged recently in Ocentro, RFRA creates a mechanism for courts to enforce it. We don't dispute that agencies should take RFRA into account, but ultimately RFRA creates a judicial remedy, and courts and agencies should be looking to guidance from the courts and ensuring that when they do exempt people, there's at least a meaningful opportunity for judicial review of their decisions.
So
Thank you.
I'm sorry.
Justice Sotomayor, proceed.
I guess the question I have is the exemption as structured permits the insurance carriers not to provide coverage?
Yes, there's no requirement that objecting entities utilize the accommodation. It's completely optional. So they can simply claim the exemption and tell their insurer don't provide contraception, and no entity has an obligation to provide it at that point.
And that
Thank
is
you.
Between what happens and how a court reviews what happens when an agency works off of an interim final rule, as opposed to when an agency works off a notice of proposed rulemaking. And I guess the question is, why should there be any real difference between those two?
So, Your Honor, I want to stress one aspect of our argument, which is that our argument hinges on whether the first rules, the 2017 rules, were themselves procedurally valid. If they were valid, then the 2018 rules are procedurally valid as well.
Okay, let me just make sure I understand that. Suppose that there were good cause for issuing an interim final rule. At that point, if the agency then says, well, that's nice, we had good cause for doing this because we had an emergency, but now we're going to notice and comment. At that point, should the notice and comment be treated the exact same way as it would be if there were no good cause rule at all?
Your Honor, if the agency has good cause to issue the rule with immediate effect, then the provisions of Section 553 simply don't apply.
No, that's not right. I don't think that's right, because the good cause can give you cause to act right now, but it doesn't give you cause to act for 20 years without notice and comment. So an agency could say, we have good cause to act right now, but now we understand that we have to do a notice and comment proceeding because now, there's something in place and we can take our time and do it.
That is certainly true, Your Honor. I apologize. If the agency wishes to modify the rule or take further comment, then yes, it can go through the 553 process if the good cause that prompted the immediately effective rule no longer applies. So that's correct.
Okay, so it not only can, but in many cases it has to. The good cause doesn't last forever. So in that kind of case, do you think that the standard is heightened when a court looks at this and says, did they do notice and comment correctly?
No, Your Honor. In that case, the standard would be the same as it would be in any other APA case.
Okay, because I thought that your reasons for why the standard should be heightened would apply even when there was when the interim rule was valid. Because as I understand your reasons, for thinking that the standard should be heightened. It's that the agency has kind of gotten psychologically used to the rule and maybe less willing to make departures from it. But that applies even when the good cause rule is valid, doesn't it?
It does, and I think that reflects a balance that Congress struck, recognizing that in most cases, prior notice and comment is the most effective means of getting to a more informed decision. In some cases, that interest is trumped by the need for an immediately effective rule. So the benefits of notice and comment have to sort of give way a little bit so that the agency could act quickly. But here, where we believe the good cause standard wasn't satisfied, the APA plainly requires the agency seek comment on a proposal.
Okay, so I'm right in saying that this really does depend on whether the good cause requirement was satisfied in the first place.
Yes, absolutely.
Okay, and then as a remedy, you say we should just go back to the original rule, but the original rule was done in the exact same procedural manner, so how would that make anybody any happier?
So there are a number of rules that have been implemented dealing with this. A number of them went through full notice and comment. In one case, there was an advance notice of prior rulemaking, of proposed rulemaking, an NPRM. In two cases since the women's health guidelines were issued, and one time before, the prior administration did immediately go to an immediately effective rule. They argued good cause. In one instance, the D.C. Circuit upheld that finding. In another instance, it was never, as far as we know, ruled on by any court. We think the arguments made were much stronger in those cases, and regardless, to be litigating this question 9 years after the fact simply doesn't make a lot of sense. What we're saying is that the good cause claims made here by these agencies and these rules have to be evaluated on their own. And if what the agencies have said here satisfies good cause, then agencies could always find good cause. And the result would be, and I think this is the most important part of our argument, if what the agencies did here is okay, every agency could say, we're just going to issue a rule, make it effective immediately, claim good cause, and then take comment. And even if they lose on the good cause finding, they don't have to worry for long, because as soon as they've taken comments and issued a new rule, then the rule will be immediately effective. And it will be as if there was no violation in the first place. And it's reasonable to think that agencies will take their cues and will say, okay, well, we're going to take the risk and we're going to do that, because frankly, there really isn't much of a risk in the end if everything will be fine once they've taken comment and issued a new final rule.
Thank you, counsel.
Thank you, Your Honor.
Justice Gorsuch?
Good morning, counsel. I'd like to turn back to where Justice Breyer left off the challenge. And I suppose the argument on the other side goes something like, one could understand an arbitrary and capricious argument about the arguable overbreadth of these exemptions. But the challenge before us is whether the agency's exceeded its statutory authority. And looking at the statute here, it's about as excessive a delegation of statutory authority, or not excessive, expansive a delegation of statutory authority as one might imagine. It talks about comprehensive regulations, and when an agency is given that kind of leeway, we normally think of comprehensive to include limitations, conditions, exceptions, as well as a general rule, because there's no rule that doesn't have an exception. And then we look at the original accommodation, and at least some suggest that original accommodation to churches was consistent with that statutory delegation. And then you throw RFRA in the mix, and that's normally thought to trump any and inform any other existing statutory obligation. So what do we do about that? I think that's what Justice Breyer is trying to get at, and I guess I'm curious for a little further thought on it.
So, yes, Your Honor, I think if the delegation is read the way the agencies would like to read it, then it is remarkably broad, and I think would, frankly, raise non-delegation problems. I think the delegation is cabined by the fact that two things. First of all, I think the structure of the section makes clear that items 1, 2, 3, 4 are all simply categories of services, even though in identifying those services, it refers to comprehensive guidelines. What begins that paragraph 4 is, with respect to women, such additional preventive care and screenings. And then the second point is that to the extent there might be...
I'm sorry to interrupt there, but I just want to understand how you read that, because it does... I've heard that a few times, there's such additional preventive care and screenings, but then ... as provided for in these comprehensive guidelines. Can you explain how those two interact, I guess?
Yes. So such, which typically means, in the manner to be indicated, refers or sort of sets the stage for as provided for. So if you're asking the question, well, what additional preventive care and screenings must be provided? The answer is such, so in the manner to be provided, as provided for in the comprehensive guidelines. So all of that is answering the question of what additional preventive care and screenings are to be provided. If you read as provided for sort of applying to the entire section, sort of going back into subsection A and modifying those requirements, then you're sort of unmooring it from the way it's used in paragraph 4 and leaving such additional preventive care and screenings without any further explanation. And in addition, I think the other three categories provide some guidance and I think reasonably cabin the agency's authority. The other three paragraphs all refer to guidelines that already existed. So HRSA had the ability to look to those, and those are all, there are no religious exemptions in those guidelines. There are no broad exemptions. They're simply lists of services, lists of vaccinations that are required, other things. So where Congress lists several items, I think it's reasonable to conclude that Congress envisions that the agencies will operate or will exercise their discretion sort of in a similar manner in each instance. And I think that's what was assumed here.
But is not part of that assumption, I think the argument is, hey, we can't specify which preventative care and screenings will be provided or under what conditions, and that any provision of care is necessarily going to be conditioned and subject to all sorts of exceptions. That's just the way the world works. There's no rule without an exception. And toward that end, again, just drawing your attention back to the accommodation for churches, many people have argued, and certainly the prior administration did, that was consistent with the statute, not something imposed upon it from outside by the First Amendment. What do you say about that?
Your Honor, so we disagree with the prior administration's conclusion that this section authorized the prior church exemption. As far as we know, that was never challenged. And
yeah, let's suppose though that was correct, and I understand that's not your position. What would follow from that for this case?
So if that were correct, then the agencies would have some discretion to create exemptions, and then I think we would be in a position where we would evaluate these rules under arbitrary and capricious review. And I think there are several problems with them, but we would not be in a world where the question of the agency's authority in the abstract was at issue.
Okay, and if I could turn quickly to one other point entirely, the substantial burden argument that Justice Alito raised. And I understand your position. I thought that there would be no substantial burden imposed by a requirement that they pay for contraceptive care. Is that correct?
No, Your Honor, not at all. I mean, that, if an employer objected to that requirement, there would certainly be a substantial burden.
Okay, all right. I misunderstood that colloquy then. Thank you very much.
Thank you, Your Honor.
Justice Kavanaugh?
Thank you, Chief Justice, and good morning, Mr. Fisher. I wanted to get your reaction to this way to think about the case, maybe picking up on Justice Breyer's question and Justice Gorsuch's first question. As a number of my colleagues have pointed out, Justices Ginsburg, Sotomayer, Alito, Breyer, and others, there are very strong interests on both sides here, which is what makes the case difficult, obviously. There's religious liberty for the Little Sisters of the Poor and others. There's the interest in ensuring women's access to health care and preventive services, which is also a critical interest. So the question becomes who decides how to balance those interests. And the answer, of course, is Congress in the first instance. And RFRA provides a backstop on that, but even beyond RFRA in the ACA, Congress is delegated to the agency. Okay, so we have a delegation from Congress to the agency, which is common, and sometimes Congress delegates narrowly with narrow language, and sometimes it delegates broadly. And the rule of thumb I've always thought is courts should construe narrow language narrowly and broad language broadly. And this seems to be broad language, as Justice Thomas noted. And when you have that kind of broad language, you're going to get different executive branches who are going to exercise their discretion within that broad language and balance the interests differently. And then the question is, what's the judicial role? And it seems to me the judicial role is not to put limits on the agency discretion that Congress has not put there. And then we're left, I think, as Justice Breyer said, and I want to get your reaction to this, with the arbitrary and capricious test at the end of the day, and just making sure that in exercising its discretion and balancing those interests, the agency didn't go outside the limits of reasonableness, which is a very deferential test. It's not abdication, but it's deferential. Why isn't that the way to look at the case? And if we get down to the bottom line of, is this reasonable, not maybe everyone's preferred choice, but at least within the bounds of reasonable, why isn't this a reasonable way to balance it? So just get your reaction to all that.
Thank you, Your Honor. So on that last point, the reason this is not a reasonable way of balancing is that the rules go well beyond what RFRA even arguably would require. As we mentioned, for instance, companies that had no objection to accommodation are now wholly exempt. And however you interpret the Women's Health Amendment, and we strenuously believe that it imposed a mandatory duty on insurers to provide this coverage, but certainly it would defeat the purpose of that amendment to say that women should not receive coverage if they work for an employer that objects to contraception generally, but was willing to participate in the accommodation process or to note its objections so that they could still receive coverage. We also think there's that the exemption for publicly traded companies, in the absence of any evidence that any publicly traded companies requested one, goes well beyond. We think the moral rule is so untethered from any reasonable standard that it's certainly arbitrary and capricious. And we also think that if we're in the RFRA world, that the way these exemptions are structured would really defeat any opportunity for scrutiny as to whether an employer claiming an objection has a sincere religious belief, whether it is substantially burdened, and would essentially remove the courts from the process entirely. And I think one point to remember is we are dealing with the interplay between two statutes. And as the court acknowledged in Epic Systems v. Lewis, ultimately deciding how two statutes work together and where the boundaries are is a question for courts. That can't be left just to the agencies. And we submit the Women's Health Amendment impose a mandatory obligation that says shall at a minimum provide coverage for and shall not impose any cost-sharing requirements for. And nevertheless, what is clear from the floor debate on that is that Congress envisioned that it would require coverage for preventive services, that family planning would be included. Now, you also have extremely important interests in RFRA and in the nature of the religious objections that are being claimed. Ultimately, courts need to resolve these questions, and the agencies have essentially taken these decisions out of the realm of the judiciary and decided for themselves. And that simply isn't how RFRA works, and under EPIC, it's not how these questions should be resolved.
Thank you very much, Mr. Fisher.
Thank you, counsel. General Francisco, you have a minute for rebuttal.
Thank you, Mr. Chief Justice. Although RFRA both authorizes and requires these exemptions, at the very least, they're justified under Section 13A4. That, after all, was the very basis for the church exemption back in 2011. It's also the basis for the effective exemption that applies to self-insured church plans, as illustrated with respect to the colloquy between my friend and Justice Sotomayor. And if you accept respondents' interpretation of the accommodation, it's also the basis for the accommodation itself. Under my friend's position, they seem to concede that all of these other provisions violate Section 13A4. After all, the church exemption is not limited to ministers, and the church exemption applies to churches that don't even object to contraception. But regardless of how you resolve the issue, the rules here bring a decade-long dispute to a durable end, and they should be upheld.
Thank you, General. The case is submitted.
Basic restriction subject to exceptions. Here we think that both challenges could have been brought, but that both would fail. But I'd like to focus first on the challenge that respondent is asserting in its brief. This is the challenge that respondents are asking the court to focus on, and that is the challenge to the underlying automated call restriction. And respondent's basic theory is that the government debt exception, taken in combination with other aspects of the statutory scheme, prevents the automated call restriction from performing its intended consumer protection function, renders it insufficiently efficacious to be upheld under the First Amendment. And we think that's wrong. If you look at the statute, the only other statutory exceptions to the automated call restriction are those for emergency calls and calls made with the prior express consent of the recipient. And respondents have not contended that either of those raises a First Amendment problem or casts doubt on the efficacy of the underlying restriction.
Mr. Stewart, one of your basic points to avoid strict scrutiny under the First Amendment is that you're not really looking at the content of the communication in this case, but rather it's more properly viewed as part of an economic relationship. I don't see how that gets you out of the content category. You still have to look carefully at what's being said before you can decide whether the phone call is covered by the provision or not. I think that's the clear holding of our decision in the Reed case.
Well, I think that, let me address Reed first and foremost. At the outset of the court's analysis in Reed, after the statement of the case, the court described content-based laws as, quote, those that target speech based on its communicative content. And if we're focusing now on the automated call restriction, the provision of the statute that respondents say is the focus of their constitutional challenge, it's impossible to say that restriction targets respondents' calls based on their communicative content. The situation was very different in Reed. In Reed, the town had 23 different categories of signs in its sign code, a multitude of different treatments of the different categories. One of them was temporary directional signs, and that was the category of signs that the plaintiffs in the case wanted to put up. And you could tell exclusively from the content of the sign which category it fell into and what restrictions applied. And in that circumstance, it was natural for the plaintiffs to argue and the court to hold that they had been targeted based on the communicative content of their signs. Here respondents haven't been targeted in any meaningful sense. Their political communications are subject to the same restrictions that apply to the vast majority of automated calls. The fact that a very
I'd like to jump ahead a little bit and get to the severance question. You say that if this exception for government debt is found to be problematic, you should just sever that and keep the rest of the statute. But when we sever provisions, it's because they are illegal. Here, there's nothing illegal about the government debt exception. It just, when combined with the rest of the statute, makes the whole statute vulnerable. I wonder why, in that situation, the whole statute shouldn't fall.
I guess the two things I would say are, first, it's important to look at the temporal sequence that produced the current state of affairs. That is, the basic restriction was enacted in 1991, and the government debt exception was enacted in a separate public law in 2015. And
okay, I've got that. What's your second point?
The second point is that the ultimate question of severability is one of congressional intent. What result would Congress have preferred? And for purposes of determining what Congress would likely have preferred, it seems really like the tail wagging the dog to say that we will treat Congress's desire to free collectors of government-backed debts from these restrictions rather as taking preeminence over Congress's desire to protect all consumers from all other automated calls. We think Congress would
Thank you, counsel. Justice Thomas?
Thank you, Chief Justice. Mr. Stewart, it would seem a bit odd, you suggest that we sever the exception, but here it doesn't seem, this remedy doesn't seem to give anything to respondent. It doesn't add any more speech for the respondent, and it seems to be taking speech actually away from someone who's not in this case.
I mean, that may be true, but the court's task in determining the appropriate remedy is to kind of follow established principles of severability, to look to indicia of Congress's likely intent, and if the result is that the plaintiff at the end of the day doesn't get the practical result that it was looking for, that's not a reason to kind of rejigger the Constitution, the severability analysis. I mean, it often is the case that a plaintiff can achieve a practical victory only by prevailing on both of two legal questions. And sometimes it is a question both of the merits of the claim and of the appropriate remedy. And if a court holds that, yes, you are right, you've established the existence of a violation, but the statute read properly simply doesn't authorize the remedy you seek, that's one of the chances that the plaintiff takes when it pursues a claim that depends on prevailing on two separate legal propositions. The plaintiff persuaded the court as to one legal proposition, didn't persuade the court as to a second proposition that was really essential to getting the practical result it wanted. That's not an unusual situation in the law.
So I'd like to shift gears and focus, just ask the question about your strict scrutiny analysis. You seem to focus on the interest that the individual has in privacy of the cell phone. But it would seem to me that that privacy interest is actually not nearly as great as you would, as a person would have in the landline phone at home or in even someone knocking on their front door.
Well, I think at the time that the statute was enacted, cell phones were obviously a lot less prevalent. They may have been used on rare occasions, and most people didn't own them. I think now cell phones are, as we explained in the reply brief, are ubiquitous. They are an integral part of daily life for most individuals. And so really the privacy interest is greater than in the residential landline. Yes, if the phone rings at your home and you happen to be there, it may be an intrusion. But most people, or virtually all people, when they are at home will have their cell phones with them. So unwanted calls to cell phones will pose the same threat to residential privacy that unwanted calls to landlines would. But in addition, people, for the most part, carry their cell phones with them at all times. And so the effect of automated calls to cell phones is not just potentially to disturb residential privacy, it's potentially to disturb them when they're at work, when they're on social occasions, when for whatever reason they might want to be open to calls from friends or calls from family members, but don't want to be distracted by.
Justice Ginsburg?
Counsel, I don't see how you can escape content-based distinction. Because if the content is a debt owed to the government, that's the content of the message. You owe the government for your student loan or whatever, then the call is okay. But if the message is, please contribute to our political organization, it's banned. So it's based on what the message is. Pay the government what you owe the government, or contribute to our political organization.
I think as we've said in our briefs, it is true that often a court, in determining whether the government debt exception applied, would look in part to the content of the call, but you wouldn't be looking exclusively to the content of the call. For instance, determination whether the particular debt that was sought to be collected was in fact owed to or guaranteed by the federal government would have nothing to do with the call's content. It would depend on the financial relationship between the debtor and the federal government. And it is characteristic in the legal culture that Congress would enact statutes that regulate communications made in particular fields of economic activity. And so you have laws that regulate what can be said or what disclosures have to be made in connection with the sale of securities. And they're subject to First Amendment challenge. Plaintiffs can argue that particular restrictions go too far, but nobody thinks of laws like that as being especially suspect because they are limited to the field of securities, even though to determine whether a particular communication was covered, a court would need to look in part at the content of the communication.
Switching to the severance, we're told that if we strike only the government debt exemption, that would leave the political groups with no incentive at all to assert their First Amendment claim, because they're going to lose at the end of the day. So why should they bother challenging, why should they bother with a First Amendment claim when it will be unsuccessful at the severance stage?
Well, a couple of responses to that. The first is, as I was indicating earlier, the plaintiffs here did argue, and they were entitled to argue, that the appropriate remedy, if there was a constitutional violation, was to strike down the whole restriction. But they didn't persuade the Court of Appeals on that question. And if the application of ordinary severance principles would confirm that result, then the court's duty is to follow those principles, even though it leaves this plaintiff without a remedy. The other thing, as we discussed,
Justice Breyer.
What your last statement and Justice Ginsburg leads me to ask a somewhat philosophical question, which you need not answer if you don't want to. But my question is, what is content discrimination? All human life is carried on through speech. All government regulation is carried on through speech. Every single statute book is filled with all kinds of content discrimination. The SEC and every agency deals with nothing but what do their rules apply to, where are the exceptions, etc. And so I'd always thought that that was in Justice Brandeis's third category, economic regulation, as far as the First Amendment is concerned, or at least most of it was. So how, in your view, do you distinguish between what is in that third category look to see if it's reasonable? What is in the first category, never uphold it almost no matter what? How? What's your way of doing it?
I don't think we have any succinct tests that would capture all cases, but I would point the court or remind the court of certain guideposts that it set up. One is, if you can tell exclusively from the content of a message whether a particular law applies, then that's very likely or almost certain to be content-based. The second is, as I was referring to earlier, the court in Reed referred to content-based laws as those that target speech based on its communicative content. And here, even if you thought that the government debt exception was content-based, it wouldn't follow that the automated call restriction is content-based. The automated call restriction doesn't target speech because of its content. It treats the vast majority of speech the same, and it simply exempts from regulation a very small category of speech. And then the third thing I would say is, whatever the right answer is, it can't be that whenever speech, the mere fact that a particular law is limited to speech that is used in a particular economic activity, that limitation cannot by itself be sufficient to render the law content-based, or at least to subject it to strict scrutiny, because that principle would cast doubt on a vast array of laws that Congress and state legislatures have enacted that regulate discrete spheres of economic activity.
Thank you. Thank you very much.
Justice Alito?
Mr. Stewart, the so-called severability issue in this case is really fascinating. I understand you don't think we need to get to that, but assuming for the sake of argument that we do get to that question, what is your best precedent for the application of a severability analysis in a case like this, where arguably a regulation of speech is unconstitutional only because it contains a content-based or a viewpoint-based exception?
I don't think either side has a precedent that was specifically in the First Amendment area where the court discussed whether severability principles should apply, and if so, how do they apply? I think our best precedents are cases like Morales-Santana and Frost. Yes, those were equal protection cases, but they said in deciding whether an exception should be severed or the underlying rule should be struck down, we look at things like the temporal sequence in which the laws were enacted, whether the exception was enacted later in the day, the degree of Congress's commitment to the basic rule. And I think those are good analogies here, where the gravamen of the First Amendment claim is that this person's speech is being treated differently from another person's speech.
Well, what is your response to this counter-argument? In an equal protection case, what the complaining party is objecting to is unequal treatment. So whether the remedy levels up or levels down, the complaining party gets what it wants, namely equal treatment. Whereas in a free speech case, what the complaining party is objecting to is a restriction on its speech. And if we apply the severability analysis in that situation, the complaining party does not get what it wants, which is the ability to speak without restriction.
I think with respect, that conflates what the complaining party wants with what it is entitled to. And for instance, in Morales-Santana, there's no question that what the complaining party wanted was citizenship. It wanted to be able to invoke the plaintiff wanted to be able to invoke on behalf of his father the constitutional right to equal treatment for unwed fathers and unwed mothers. And yes, the gravamen of his claim is, I have a legal entitlement to equal treatment, but what as a practical matter the plaintiff wanted was citizenship, and he didn't get it as a result of the court's severability holding. The court said, we apply established principles of severability in order to determine what we think Congress would have intended, and the consequence is that even though you have established a violation of the right to equal treatment, you are not entitled to the practical result that you are seeking.
Thank you, counsel. Justice Sotomayor?
Counsel, the difficulty in my mind with this case has been just touched upon by Justice Alito. Assume that I do think, or assume not that I think, but assume that this law is content-based. I don't see in the record any evidence by you of how small this exception is. The other side says that most of the complaints to the FTC are because of debt collection. But there are no statistics about how big or small debt collection is with respect to robocalls generally, or with respect to consumer collection. And even if you could show me that they were a small part of the intrusions on people, they certainly are a big emotional complaint because they generate the most ire by citizens. But putting that aside, you haven't shown me why government-backed debt calls are any different than commercial calls, private commercial calls for debt. In both situations, the debtor would expect a call about debts they own. That's an interest that the government's claim, but, so what? Both debtors. So there is a discrimination aspect to this case that does raise the equal protection ground. But putting all of that aside, given that the burden is on you under strict scrutiny to show that you've narrowly tailored a law, if this is content-based, and with all the failings I've pointed to, how do you win on validating this act?
Let me say two or three things about this. First, I think it would be impossible to make an empirical showing about kind of the smallness of the exemption relative to the whole, because what you would want to compare the government debt calls to is not to other calls that are actually being made in the world, because a lot of the calls that would otherwise be made are not being made precisely because they're barred by the TCPA. What you would want to be asking is, how small is this comparison how small is this class in comparison to all of the other automated calls that might be made if the TCPA were not enforced. Second, with respect to potential discrimination between collectors of government-backed debts and collectors of other debts, the distinction that we pointed to is that the collection of government-backed debts implicates the distinct federal interest in protecting the federal fisc, and it's not unusual for Congress to prefer federal debt collection efforts. For example, if Congress says the federal government can collect debts owed to it by offset on a tax return, a tax refund, or Social Security benefits, but private creditors can't do that, or if the federal government has greater capacity to garnish wages, there's nothing problematic about that. The last thing we would say is, collectors of private debts could petition the FCC for an exception. They could say there's no good reason to treat us differently, and therefore you, the FCC, should exercise your statutory authority to create an exception for all debt collection calls as to which the recipient is not charged. And then the FCC would either grant or deny that. If it was denied, there could be judicial review. So there could be a more targeted challenge that was premised on the differentiation between government-backed debts and others, but that's very different from
Justice Kagan?
Good afternoon, Mr. Stewart. Can we go back to what you started with? You said that there was no right way to think about how to analyze this question, that we could either apply constitutional analysis to the automated call restriction, or we could apply it to the exemption for government debt. I'm wondering whether you could say a little bit more about that, because we have to pick some way. And on the one hand, the restriction is the only thing, the automated call restriction is the only thing prohibiting speech. But on the other hand, the exemption is the only thing that creates the constitutional issue in this case. So which end of the statute should we look at?
Well, let me preface my answer by pointing to a hypothetical that's noted in the respondent's brief that we think is a good illustration of when it would be appropriate to focus on an exception. At page 22, respondents hypothesize a statute that has a categorical ban on all automated calls except for automated calls to a residential landline that endorse the reelection of Donald Trump and that are approved by the Trump campaign. Now, we think an exception like that for calls made to endorse a single political candidate would surely violate the First Amendment. It would be not only content-based, but viewpoint-based, and there'd be no good justification for it in terms of the basic rationale for the restriction. And even if a court concluded that this was a very small percentage of calls, the exception didn't cast doubt on the credibility of Congress's overall privacy protection objectives, even if it didn't significantly interfere with the achievement of those objectives, the court would surely say that the exception was invalid. And in that circumstance,
is this statute like that statute?
I don't think it's like that statute. I mean, the last thing
obviously not in the sense of it's not the exemption is not viewpoint based to the extent that that statute is. But you've heard some arguments that the exemption is content based. So why not treat it the same way?
I mean, I think at the very most, you would treat the exemption in the same way that you would treat it if a restriction were imposed based on the same criteria. And if there were certain restrictions placed on the collection of government-backed debt and only on the collection of government-backed debt, you wouldn't apply strict scrutiny to such a law for the same reasons I've discussed with respect to the securities laws, other hypothetical laws that could restrict communications in a particular area of commerce. Now, respondents have understandably focused their attention on the automated call restriction, in part because of the severability question. If they could persuade the court that the exception was the invalid provision and it was struck down, they wouldn't really get what they want. But they have to establish distinct prerequisites to show that they have a valid constitutional challenge to the automated call restriction. One might be if the exception taken in combination with other features of the statute just made it seem as though Congress wasn't serious about protecting privacy. But the exception really can't.
Justice Gorsuch?
Good morning, counsel. Some of my colleagues have already noted that the irony of a First Amendment challenge leading to the suppression of more speech as a remedy. I guess I wanted to explore that just a little bit further. As I understand it, you've taken the position that there's no right way to do severance here. But should we take cognizance of the fact that striking down the government debt provision was not relief that the plaintiffs sought in this case? And we normally take some cognizance of the adversarial process and the plaintiff's request for relief. We chided plaintiffs earlier in this term for not including all the relief they might have wanted in their complaint. And what do we do about the fact as well that the plaintiffs would seemingly have no standing to challenge an exception for government debt collection activities? So they didn't seek the relief and they don't have standing for this relief. Should those things tell us anything?
I mean, I think that you could do it that way, and the Court of Appeals could have done it that way. That is, the principal argument that the respondents have made all along is that the government debt exception combined with other features of the statutory and regulatory scheme really call into question Congress's commitment to the protection of privacy or prevent the statute from achieving that objective. And the Court of Appeals clearly didn't think that that was right. And the Court of Appeals could just have said, that's the only claim you made, I reject it. And whether or not you could have pursued a valid challenge to the exception itself, you haven't sought to pursue one, and therefore I'm not going to consider it. I think given that the Court of Appeals ruled as it did, we have tried to confront that argument on the merits. With respect to the standing question, what the respondents have always sought as relief invalidation of the automatic call restriction, and they clearly have standing to seek that. And if the court holds that, yes, they're right that there's a First Amendment violation, but they are wrong about the remedy, that would not be a problem of standing. That would just be a problem on the merits of their claim, or at least the merits of their claim with respect to the appropriate remedy.
Let me come at it from yet another angle, and that's the separation of powers. the government's remedy proposed here is essentially that we should suppose or reimagine that Congress would have preferred a regime in which more speech is suppressed than one in which less is suppressed. On what authority do we have the right to make that kind of judgment, as opposed to simply enforcing the First Amendment, finding a violation, and liberating the speech that's been wrongly suppressed?
Let me say two or three different things about that. The first are either invalidation of the exception or invalidation of the restriction would produce a constitutional version of the TCPA. So from the standpoint of compliance with the First Amendment, neither is to be preferred. The second thing is courts face that same question when you're doing severability analysis in the equal protection context, where the result of severance may be that particular individual.
If I might stop you there, I'm sorry, but the equal protection analogy, suppose that doesn't work for me, because equal protection is a guarantee of equality, not of a substance. So you can level up or level down and satisfy equal protection, but the First Amendment is about a guarantee of speech, so it has content in a different way. So suppose that argument, then what do you have?
Let me say, I think what we have is the temporal sequence here, where we had one public law in 1991 that enacted the basic autodial restriction, and then a second public law that was enacted in 2015. And if there is a constitutional infirmity, if you ask which public law introduced that constitutional infirmity, it would have to be the 2015 public law.
Thank you, counsel. Thank you, counsel. Justice Kavanaugh.
Thank you, Mr. Chief Justice. Good afternoon, Mr. Stewart. I think the government debt exception is almost certainly content-based, at least for me. And I just wanted, as a matter of housekeeping, you don't argue that it could satisfy strict scrutiny, correct?
That's correct. We've argued that the automated call restriction could satify strict scrutiny, but not the
so if those two things together make this, for me at least, a case about severability and leveling up or leveling down. And you were just on this with Justice Gorsuch, but it would help me if you could kind of tick through your strong points about severability again.
I think that the two strongest points, and then I'll link to the second to the Communications Act severability clause. The two strongest points are, we think there would be a tail wagging the dog quality to striking down the whole restriction, one that has been in place for nearly 30 years, that has been popular with consumers, that has protected a vast array of people, simply to preserve the ability of government debt collectors to use one more means of communication. The second is the temporal sequence. If we ask which law was it that introduced any constitutional invalidity, it would have to be the 2015 law, not the 1991 law. And so it would be natural, if you were otherwise an equipoise, to say that's the law that would be struck down. And then there is a severability.
Go ahead.
I was going to say there is a severability clause that says if any provision of the Communications Act, of which the TCPA is a part, is held to be invalid, the remedy won't extend beyond striking down that provision. And for purposes of determining which is the invalid provision, I'd refer back to my point about temporal sequence. It is the 2015 law that introduced any constitutional infirmity.
So a key point I think you just underscored there is that the premise of your severability argument, essential premise, is that the underlying ban is thoroughly constitutional.
Or at least that the underlying ban was constitutional before 2015.
Yes. That's without the exception. I meant to say without the exception, the underlying ban is perfectly constitutional.
Yes.
Okay. And how much should we take into account on the what would Congress have intended analyses like we see in the state's attorney general's brief about consumer beliefs about these calls, that the common consumer complaint about robocalls. Does that go at all into our analysis of what Congress would have intended?
I think certainly this was not unnoticed legislation. It's not legislation that fixed a technical problem. I'm talking about the original TCPA now. This is legislation that was intended to address a problem that Congress thought was immense, that affected vast numbers of consumers. And obviously the amicus briefs describe complaints that are being made now about robocalls, even with the TCPA's restrictions in place. And so,
thank you, Counsel. Would you take a minute to wrap up, Mr. Stewart?
Thank you, Mr. Chief Justice. The last thing I'd say is I'd refer back to the point that I was making at the beginning, where given that respondent is asking the court to focus on the restriction and not the exception, it's appropriate to ask whether the restriction is content-based, as the court in Reed understood that term. And the court in Reed described content-based laws as laws that target speech based on its communicative content. Respondent speech was not targeted based on its content. It was treated the same way as the vast majority of messages that people could use automated calls to transmit. Thank you, Your Honor.
Thank you, Counsel. Mr. Martinez?
Mr. Chief Justice, and may it please the court, my clients are political organizations that want to engage in political speech at the core of the First Amendment. The TCPA bars them from using some of the most effective tools for communication now available, automated text messages and calls to cell phones. At the same time, the statute's exceptions let government-approved speakers use these same technologies to deliver government-approved messages that subvert the same privacy interests supposedly requiring a ban on all other calls. This content-based scheme arbitrarily favors commercial speech over core political speech. It violates the First Amendment and should be struck down. The call ban is extremely broad. Although the TCPA's primary purpose was to address telemarketing calls, the cell phone ban sweeps further and outlaws political and other non-commercial calls, even when citizens are open to receiving them. The government says Congress needed a restriction that broad in order to protect privacy. The statute's history disproves that. Congress and the FCC exempted non-commercial calls from the residential call ban after concluding that they do not adversely affect the privacy rights protected by the TCPA. There's no good privacy-based reason for treating these exact same calls differently when made to cell phones. The government debt exception confirms that Congress did not view the privacy interest here as compelling. That exception exposes 60 million Americans to unlimited calls to collect more than $4.2 trillion in debt. Those are the kinds of calls consumers hate the most. If Congress really thought privacy was paramount, it would not have allowed those calls. Because the speech ban is too broad and unjustified, the restriction, not the exception, must be struck down. That's what the court has always done in First Amendment cases, and rightly so. Federal courts cannot fix First Amendment violations by making more speech illegal. This court should reject a remedial approach that eliminates incentives to challenge unconstitutional speech bans and gives my clients no relief, even though they won their First Amendment claim.
Mr. Martinez, I'd like you to focus on the argument based on our decision in Williams U. Lee, which is that when Congress takes steps that help cure a constitutional problem, they don't have to do everything at once. You object to the fact that some speech is allowed, but the allowance doesn't reach more broadly. And what we said in Williams U. Lee, again, is so long as Congress is moving in what the court regard as the right direction, they don't have to do everything at the same time. So the fact that you say we should allow more speech here, here, and here, again, it doesn't mean that it has to be done at the same time as the first step was taken as it was here.
Right, Your Honor. And I think what the Williams U. Lee inquiry is really getting at is whether the exception undermines the credibility of the government's interest that it's been asserting. And I think in this case, the 2015 exception really does undermine that, because it's not getting at, it's not trying to exempt the least intrusive of privacy speech available. It's actually exempting the kind of speech that the FCC itself has acknowledged is the most intrusive kind of speech, and those are the debt calls. And so Williams U. Lee, I think, is talking about a situation in which the government or Congress is trying, or the legislature is trying to accommodate kind of the speech that that is least problematic from the standpoint of the interest that's being asserted. But here, Congress has done the opposite. It's exempted the speech that's most problematic. And I think that really makes this a different case from Williams v. Lee and brings us squarely within the concern that Williams v. Lee had, which is that when Congress enacts broad exemptions like the one here, it might actually be a sign, it might be evidence of the fact that the interest that the government has asserted for a speech restriction really isn't that strong. And I think that was the base.
Your friend on the other side on the severance question makes a very strong point that Congress had this law for 25 years, and then they added this, pretty discrete exception that created the problem we have today. It seems pretty obvious that the way they would solve it is get rid of this exception. It's an extremely popular law. Nobody wants to get robocalls on their cell phone. The idea that Congress would embrace that result simply to save this government debt collection, they'd have to be very anxious to be more unpopular than they otherwise would be.
Well, two points on that, Your Honor. First of all, I think that the fundamental problem here is the invalidity of the restriction, and I think that even before you get to any severability inquiry about intent, we have to be very careful and specific about what is unconstitutional about the statute. And I think what the 2015 exemption shows, as well as the much more favorable treatment to political and non-commercial speech when it comes to calls to home phones, what those show is that the privacy interest here really isn't compelling, and that the restriction is what falls. So you don't even need to look at severability. But even as to the intent...
Justice Thomas?
Thank you, Mr. Martinez. The problem that I have is you just said that the issue, that the real problem here is the restriction. But the evidence, the focus here is on the exception. And if you solve the exception problem, it doesn't solve your restriction problem, particularly if you sever that. And that's the sort of the asymmetry that's coming out. The problem is one thing, that is that the restriction, but the constitutional problem is really the exception. So why don't you, I'd like you to explain what you just said, why the restriction is the constitutional problem as opposed to the exception.
Right, and let me start with the two things that I think the exception does. Number one is it introduces a content-based distinction, and it defines the scope of the restriction, and therefore triggers strict scrutiny. But number two, and more importantly for purposes of our constitutional theory, what the exception does is it reveals the underlying frailty, the underlying insufficiency of the justification for the restriction. And why does it do that? It does it because you have Congress saying, because we want to get more money, we are willing to trade off privacy for revenue. And so Congress is coming in and making a judgment that money is more important than privacy.
So what would your argument be if the exception did not exist?
If the exception did not exist and we were looking at the law today, I think our argument would be weaker, but I think we would still be able to show that the restriction would be unjustified. And I think the main thing
what would the analysis be?
The analysis, the statute would no longer be content-based, so we'd be applying intermediate scrutiny. But I think in the context of applying intermediate scrutiny, we would look at the fact that calls to residential phones, where calls to the home, where privacy matters the most, these same types of political and non-commercial calls that my client wants to make are perfectly allowed. And so Congress and the FCC have made a judgment, and this is clear if you look at the 1992 order from the FCC. Congress and the FCC have made a judgment that non-commercial and non-telemarketing calls do not adversely affect the privacy rights that the TCPA protects. And they made that clear by essentially allowing those calls at all times of day to home phones. And so if you have that indicator of congressional intent, that they're not really worried about political calls and non-commercial calls, and they're not worried about that as an intrusion of privacy, then there's no rational reason to treat cell phones differently, and Congress certainly didn't make that judgment. Of course, in this case, we have not only the differential treatment of residential calls, but we also have the evidence provided by the 2015 exception, which shows that they're willing to trade off privacy for money, even though everyone would agree that collecting more money is not a compelling interest. And so you have Congress.
Justice Ginsburg?
Your challenge is predicated on the government debt exemption. I thought that the statute as originally enacted the statute as originally enacted did have an exception for calls made by the government itself or government agency. Isn't that true?
It's true that the definition of person, or at least as interpreted by the FCC, is that the statute does not apply to the government itself. And
no one challenged that exemption for 20-odd years. One characterization is that this is really a manner restriction. That is, it doesn't prohibit calling, it doesn't prohibit conveying a message, it just prohibits using a certain automated technology to call. So it's a manner of communication. It's not a restriction on the message.
Well, Your Honor, with respect, I do think it's fair to say that this is a restriction on a certain manner of making calls, but the types of calls that are either made legal or illegal, the dividing line between what's allowed and what's not allowed turns on the content of the calls. I think that if you were facing a statute that said, for example, you are not allowed to advocate for libertarians using email or using phone calls or using handbills, all of those would be manner restrictions. But I think that we would all recognize that those are content-based restrictions that would trigger strict scrutiny and would inevitably fail.
On your severability, we know that what Congress wanted to stop were out-of-the-blue calls that you had no reason to anticipate. And calls about debts owed to the government can be regarded as less invasive in that respect because they're not out of the blue. They are simply a reminder of an obligation that the debtor undertook.
Your Honor, with respect, I don't think that that's the original justification for this particular provision, and I would point to two things. First of all is the fact that the kind of out-of-the-blue calls that my clients might want to make, political calls, those are calls that were perfectly allowed and were perfectly acceptable to the home when Congress and the FCC acted in the early 90s. And at that time, of course, home phones were, over 90% of the phones in America were home phones. That's where the privacy interests were at their apex. And nonetheless, Congress and the FCC recognized that the kinds of calls my clients want to make don't tread on privacy interests enough to warrant that kind of restriction. And I think what that just shows is that, again, the privacy interest being asserted here isn't really strong enough. Even if you go look at what the FCC said about this, and I would look at the 1992 NPRM, especially at pages 8773. At page 2737, and then the 1992 order at 8773, because there the FCC said that non-commercial, non-telemarketing calls can be exempted without undermining the TCPA. If that's true, then there's no reason.
Justice Breyer. Justice Breyer. Justice Alito.
Mr. Martinez, I'm interested in your analysis of the severability question, and I wonder if you could say whether your position depends on either the breadth of an exception or exceptions or the manifestation of congressional intent. So let me give you an example, a fanciful example that tries to reduce both of those things, perhaps their lowest limit. Suppose there was a total ban on automated calls to cell phones or to all phones, but there was one tiny exception for, let's say, calls between noon and 1 p.m. on the 4th of July that contain this simple message, happy birthday, America. And let's say that the statute allowing this contains a provision that says that if the inclusion of this exception renders the statute unconstitutional, the statute itself shall remain in force and the exception shall be stricken. So would you say even in that situation, the whole statute would have to fall?
Your Honor, let me try to address that in each of the two pieces, because I think it's a nuanced question and deserves a nuanced answer. First of all, with respect to the narrowness of that particular ban, I think that the fact that that particular restriction or exception is so narrow, I think that probably, looking at the totality of the circumstances, we would look at that and we would think the existence of this one tiny exception and the fact that this really isn't going to invade privacy that much, I think that would probably be a reason to conclude that the restriction is not unconstitutional. And if that's true, then of course the severability analysis wouldn't be necessary. If you take the other part of your hypothetical, though, if as I understand it, if the statute had a provision in it that essentially said if the restriction fails, you should nonetheless sever the exception and reinstate the restriction, I don't think that that would be appropriate, because I think the reason that the restriction would fail in that circumstance is that it's insufficiently justified. And getting rid of that exception doesn't solve that problem. The exception, again, assuming that the exception was big enough to actually create a problem, a constitutional deficiency with the statute, the exception is evidence of why the restriction is unjustified. And so getting rid of that doesn't solve the problem with the restriction.
That does seem to thwart a pretty clear manifestation in congressional intent, but you think that's irrelevant in this situation?
Well, I think in a circumstance, Your Honor, and I don't think the government disagrees with us on this. If you look at pages 17 to 18 of their reply brief, they essentially agree that if the problem with the statute is the restriction, then the restriction has to fall. Now, I think there's another way to look at the case, and I think my friend on the other side has sort of tried to frame it this way. If you thought that the only problem with the statute was not the justification for the restriction, but rather the fact that there's differential treatment, we think that you still, as a First Amendment matter, for a number of the reasons already mentioned, that you would still need to get rid of the restriction. But even if you didn't agree with us on that, I think there's our fallback position would be the position the Third Circuit took in the RAPA case, which is that you'd need very specific evidence of congressional intent. And I guess in that case, in your hypothetical, if your hypothetical expressly addressed this situation, then maybe in that case, the exception would be severed. But again, that is not the case here, because here the underlying restriction is what's unconstitutional.
Thank you, counsel. Justice Sotomayor.
Mr. Martinez, are you taking the position that all restrictions of robocalls are unconstitutional, or that just a broad restriction like this one is unconstitutional because there's some types of speech that should not be covered?
Well, I think, Your Honor, in this case, obviously we're dealing with the statute at hand. I think that there are some restrictions on robocalls that I think that probably would satisfy the appropriate level of scrutiny. And just to take one example, the way that the ban on calls works to home phones right now, it's essentially a ban on commercial telemarketing robocalls to the home. And that's the kind of that is the heart of what the TCPA was getting at. And that's what Congress and the FCC said, this is really the core privacy that we're trying to protect. I think that kind of statute
Mr. Martinez, and I agree with you, and I can think of others. If any schemes to get money, because there's so many scams from robocalls, but putting all of that aside, assuming that there is part of the restriction that could survive strict scrutiny under your claim, why shouldn't we limit any remedy striking down this provision simply to permit the types of calls that your clients make?
Well, Your Honor,
why should we be striking down the entire statute? Now, you would have to prove, and I don't know that the court has done this below, that restricting political speech is not narrowly tailored, and I don't know that that's been done in this case. But if the issue is the remedy, shouldn't we let the circuit below decide that question?
Well, Your Honor, 2 points on that. First of all, we brought this as a facial challenge. We, of course, would welcome the kind of relief that you've hypothesized, although we do think that the appropriate relief here really is to strike down the restriction in its entirety. And one of the reasons for that is the point that you raised with Mr. Stewart earlier, which is the entire absence of any evidence or justification for this particular ban for any of it, all of it or pieces of it, that the government has completely failed to put forward. I mean, this statute is subject to strict scrutiny, and this court has said over and over again that the government is the one that bears the burden of satisfying strict scrutiny. They address strict scrutiny in, I think, a single sentence with respect to the restriction, a single sentence in their opening brief, a single substantive sentence in their reply brief, and nothing else. They're trying to turn strict scrutiny into a rubber stamp. And I think the best thing to do in these circumstances is hold the government to its burden of proof, invalidate the restriction, and then Congress can come back and act and legislate in a way that's rational in light of the court's decision.
Thank you, counsel. Justice Breyer.
Good, thank you. I'm sorry. The telephone started to ring, and it cut me off the call, and I don't think it was a robocall, and we got it straightened out. Okay, my question is this. Forget the political part of this. Assume it's out of it. So now, what worries me is if you call this calling for strict scrutiny, I guess the government's justification, which is that government debt is owed to us all as taxpayers, private debt is not, so treat it specially. Well, there are many situations, food and drug agencies, agricultural agencies governing selling, the FTC, the SEC, where they will have regulations, and the regulations will have a broad category, and item X falls within it. Lamps may fall within categories that require you to put electricity regulation on. How many amps does it use or whatever? But then you discover a subcategory of the one you just put in, and you say, leave out the subcategory for some reason. Now, if court starts criticizing that for strict scrutiny, well, very few will survive. But the normal way of looking at it is it a reasonable thing? Justice Brandeis's third category. Very well. Why does this case fall into strict scrutiny once I get the politics out, but not Justice Brandeis regulation?
Your Honor, a couple of points on that. I think this case falls into strict scrutiny because it satisfies the test for what constitutes a content-based restriction that was set forth in Reed. And as I know Your Honor will remember—
You realize that what I'm doing is I dissented, and I'm wondering whether to stick to that approach or not. So Reed will not convince me. It's a good majority, but I didn't think good enough.
Well,
okay?
I would hope that stare decisis would be a factor, even if you disagreed with me.
Yes, okay, but that isn't what I'm trying to get at. I'm trying to clarify my own thinking on it.
Fair enough, Your Honor. Well, I don't think you should be concerned about the prospect of other laws that are economic regulations sort of being impacted by this at all, because I think
that's what I want the answer to. Exactly why.
Right. In those cases, those kinds of restrictions that sort of get tangled up with speech in the context of those kind of regulations, those would be at most commercial regulations of speech, which wouldn't be subject to strict scrutiny, regardless of whether or not they're considered content-based. So, for example, the government lists a number of statutes in its brief that it says, the sky is going to fall and all those statutes are going to be unconstitutional if we win, and that's just simply not true. At most, those statutes would be regulations of commercial speech at most, and if so, they would trigger intermediate scrutiny under this court's settled doctrine.
And this isn't thanks.
Justice Kagan.
Good afternoon, Mr. Martinez.
Good afternoon.
I'll give you a hypothetical. Suppose this statute was written in a slightly different way, and it exempted any calls between the holder of a government debt and the debtor. Would strict scrutiny apply?
Your Honor, I think that in that circumstance, the regulation would not turn on the content of the calls, and so I don't think strict scrutiny would apply for that reason.
Right. In other words, it would turn on the relationship. And so I guess the question is, what's the difference? I mean, that's what Congress was trying to get at, and maybe they didn't know all our arcane First Amendment rules, but that regulation basically covers a particular kind of economic activity, the collection of government debts. And this regulation covers the same kind of economic activity, the collection of government debts. There are two ways of getting at the same thing. Both are directed at the economic activity of the people involved. Why should there be any difference?
Well, with respect, and perhaps I misunderstood the hypothetical, Justice Kagan, but I thought in your hypothetical that as long as the relationship element was satisfied, the call could be on any subject whatsoever. In other words,
we know that holders of government debt call debtors, to collect debts. That's what they call them for. They're not calling them to discuss political issues.
Well, with respect, Justice Kagan, I'm not sure that's right, and the FCC has expressly addressed this situation in their August 2016 order at page 9087, where the FCC has contemplated, it's discussing and addressing the content of the calls at issue being made by collectors of government-backed debt, and it contemplates that the subject matter of the call might range beyond the collection of government-backed debt. Maybe they're going to be marketing some other product. Maybe they're going to be saying, hey, call your congressman and change these laws that apply to banks. And what the FCC has said is that when the subject matter of the call ranges to the topics, then the call is transformed, and it's a call that would have been allowed and is no longer allowed. And so I think that the content of the call is different here.
Excuse me. I guess a technical issue, Mr. Martinez, but I guess what I'm saying is that there are two ways where Congress is trying to get at the same thing, which is the calls between debt holders and debtors almost always about the debt. But, why should we care? Even if Congress didn't write this in exactly the right way, why is it that we should care so much as to put strict scrutiny into place? This doesn't raise any real concerns about government censorship, about the suppression of ideas, about a distorted marketplace of ideas. Why is this an appropriate time to put strict scrutiny into place, given that what the government, what the legislation is trying to get at is an economic relationship and the things that flow from that relationship?
Your Honor, I think that the robust test for content-based speech restrictions that this court adopted in Reed is important because it protects liberty. It makes it harder for Congress to enact broad speech bans that affect everyone, while at the same time assuming it can then just carve out special exemptions for favored groups. And I think the way to police that problem is by making sure that Congress has to be very careful before it enacts the broad ban and make it clear to them that they can't just do that and then, for example, as in this case, delegate authority to a government agency to hand out specialized exceptions for whatever well-heeled party turns up and claims an exemption. And so I think that is one of the...
Justice Gorsuch?
Counsel, I'd like to just turn back to the intuitive appeal of the government severability argument. If, as I think you've conceded, that the statute before the government debt exception would not have been content-based and might have been permissible under the First Amendment, Congress then comes in and adds the government debt exception, and that changes the equation. The intuitive argument based on that sequence of events is, well, just get rid of the government debt exception, and we go back to the status quo ante where everything was fine. Why should we reject that intuition?
I think there's a philosophical reason and a historical reason. The philosophical reason is essentially that in the First Amendment context, courts should not be making more speech illegal because if courts take a certain type of speech that Congress expressly chose to allow, and then courts make the decision to prohibit that speech, they're essentially stepping into the legislature's shoes and making very sensitive policy trade-offs that indisputably cut against First Amendment interests, and they shouldn't be the ones to do that. philosophically as well, you need to make sure that people have incentives to challenge unconstitutional laws. I think as a historical matter, though, I think it's important to recognize that the original justification for the ban on cell phone calls here was essentially that those kind of calls to cell phones would inflict charges on called parties. And that's the reason that the ban was in place originally, and that's why it may have been justified earlier. But in today's world, those call plans essentially don't exist, or are overwhelmingly, people are not charged when they receive calls to their cell phone. And so the historical facts are different now. And because of the fact that everyone has cell phones, the government has an especially strong interest now from a revenue perspective of making those debt calls. If you take all that and wrap it up together, I don't think there's a good historical basis or empirical basis for concluding that, in fact, we know with certainty, or the kind of certainty we should have in the First Amendment context, that Congress would have wanted to reenact this statute if it wasn't allowed to make the calls to collect government-backed debts.
Let me see if I've got at least that second point, my hands around it. The argument is that maybe the first Congress that enacted the original statute thought that all robocalls should be prohibited, with some exceptions that you have no complaint with. The second Congress, acting in a different time, had a different judgment about which calls should be permitted, and that included this government debt exception. We don't know whether the second Congress, enacting the revised statute, would prefer a situation in which all calls are prohibited or all calls are allowed. Does that sum it up?
I think that sums it up with one small caveat, which is that we are talking now on the assumption that there is a severability analysis that's required here that turns on intent. I do think our primary position is that the nature of the First Amendment and the nature of the constitutional flaw in this statute, which is the flaw with the restriction, we think that means that essentially under everyone's understanding of the severability principles, the restriction must be struck down.
Thank you, counsel. I'm sorry, Justice Gorsuch?
No, I'm fine. Thank you, Chief.
Justice Kavanaugh.
Thank you, Chief Justice. Good afternoon, Mr. Martinez. On severability, we have no precedent either way on severability, as I understand it, when the First Amendment problem is created by an exception to a ban on speech, rather than the First Amendment problem being created by the underlying ban without the exception. So I don't think we have any precedent either way. And the question, as you've pointed out, Mr. Stewart's pointed out, is level up or level down as the remedy. The key first question, and I asked Mr. Stewart about this, I want to make sure I have you on this, is the underlying restriction here, the underlying restriction on cell phone robocalls, constitutional without the government debt exception? So I want you to focus exactly on that question.
Yes, we think that given all the evidence we know now about what Congress's interests are and how strongly they believe or don't believe in the privacy interest, we believe that the restriction is unconstitutional. And I think the two... Let
me just make sure I have you exactly right. The underlying restriction, if there had never been a government debt exception, let me phrase it that way, if there had never been a government debt exception, is the underlying restriction unconstitutional?
We would say yes, based primarily on the differential treatment of the residential call bans. But I just want to say one thing on that, Justice Kavanaugh, because if you want me to hypothesize that the 2015 law had never been passed, I think that the 2015 law, if you think about that law as evidence of what Congress thought about privacy, the fact that it wasn't passed doesn't mean that deep down Congress believed in privacy more than than was later revealed. And so I think it's important to recognize that in our argument, the role of the 2015 exception is not merely to introduce the textual content-based distinction, but it's also to reveal the underlying lack of justification, which was always there. And again, Congress...
I guess on that point, I would pick up on what the Chief Justice said and the state's amicus brief. And if you just take a peek at the real world here, this is one of the more popular laws on the books because people don't like cell phone robocalls. That seems just common sense. Do you want to argue against that common sense?
I think aspects of the law are popular. I think, the head of the FCC has called this law the poster child for lawsuit abuse. And the reason for that is, and this isn't directly implicated in this case, there's a whole bunch of other problems with the law as well. And so I think this law has its supporters and its detractors, but I don't think you should worry about Congress's ability to protect people. Even if we win this case, Congress is going to have plenty of options that are fully constitutional in order to protect people from unwanted calls. It can focus on the telemarketing calls. It can expand the remedies available under the do not call list, which essentially allow consumers and recipients to opt out.
Even if you lose this case, Congress can, of course, scale back what you view as overbroad restrictions. But if you lose this case, Congress will still have in place a restriction that's been on the books for 30 years and that has been perceived as constitutional, and that is very popular.
Well, I guess what I would say is that I think the right way to think about this is to apply the doctrinal tools that you always apply in First Amendment cases, even in cases where the speech involved is not popular. I mean, the First Amendment is there not just to protect speech that people like, but to protect speech that people might find offensive or annoying.
Thank you, counsel. Mr. Martinez, would you like to take a minute to wrap up?
Thank you, Your Honor. The core purpose of the First Amendment is to protect the free exchange of political speech, even when people might find that speech to be a nuisance. That's what this court recognized in the Martin case when it said that the First Amendment rights protect people from making intrusive door-to-door solicitations. That's protected activity. The calls at issue here are protected activity as well. We ask you to do what you always do in First Amendment cases, strike down the unconstitutional restriction on speech. Thank you, Your Honors.
Thank you, counsel. Mr. Stewart, you have rebuttal.
Thank you, Mr. Chief Justice. I took Mr. Martinez to acknowledge that if this were a restriction on speech undertaken to collect a government-backed debt, it would be subject at most to intermediate scrutiny because it would be commercial speech and would be subject to distinct First Amendment treatment on that basis. And the position of the other side is this provision should be reviewed more skeptically, should be subject to more searching review because its effect is to take particular speech out from under regulation rather than to regulate it. And that's contrary to the usual understanding that the First Amendment exists to foster speech. It's contrary to the court's reference in Reed to laws that target speech because of its communicative content. Why would the court review more skeptically a law that looked at the same basis as a rationale for exempting speech rather than to regulate? The second thing is Mr. Martinez said many times that Congress and the FCC have exempted non-commercial calls from the automated call restriction. And I think that really overlooks the respective responsibilities of Congress and the FCC. Congress has broadly regulated at least calls using a pre-recorded voice or an artificial voice to residential landlines, just as it has calls to cell phones. Both of the underlying bans encompass non-commercial calls. Congress has vested the FCC with broad, though not identical, authority to exempt particular categories of calls from the residential and the cell phone ban, respectively. And you can look at page 5A and 6A of the appendix to the government's merits brief to see that the exemption authority is basically comparable. The discrepancy under current law results from the fact that the FCC has exercised its exemption authority much more robustly with respect to residential landlines than it has with respect to cell phones. That can't create a facial constitutional infirmity in the statute itself. If people think that the FCC should adopt comparable exemptions for non-commercial calls to cell phones, they can file a petition to that effect. The last thing I'd say in respect to goes to the colloquy between Mr. Martinez and Justice Kagan, where Mr. Martinez said, yes, if they had framed it not in terms of the content of the call, but in terms of all calls from the holder of a government-backed debt to the debtor, that would be subject to more relaxed scrutiny. And that would simply, an approach that distinguished on that basis would simply encourage Congress to enact laws with more of a broad brush. It would discourage Congress from trying to fine-tune laws, and that discouragement would only be exacerbated if we took the respondent's approach to severability, striking down the whole law. Thank you, Mr. Chief Justice.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.